The joint hearings of the two select committees will come to order. This morning our witness is Mr. Bretton Sciaroni. Mr. Sciaroni, would you please stand to take the oath? Would you raise your hand? Do you solemnly swear that the testimony that you are about to give to these committees will be the truth and the whole truth?
I do.
Thank you, sir. You may be seated. I understand you have an opening statement. Am I correct?
I do.
Would you proceed, please?
Certainly. My name is Bretton G. Sciaroni, and I serve as counsel to the President's Intelligence Oversight Board. The board was established by President Ford in 1976 to inform the President on intelligence activities.
Mr. Sciaroni, excuse me for interrupting you. Would you pull that microphone right close to your mouth, please?
Certainly.
It'll be helpful to us. Thank you.
The board was established by President Ford in 1976 to inform the President on intelligence activities which may violate the Constitution, the laws of the United States, executive orders, or presidential directives. The board is comprised of 3 unpaid board members, a full-time counsel, and a secretary. Under presidential directive, the heads of departments and agencies, the inspector generals and general counsels of the intelligence community are required, to the extent permitted by law, to report to the board on intelligence activities that they have reason to believe may be unlawful. While the board is clearly dependent upon this reporting mechanism for its information, it is also vested with investigatory authority and, to the extent possible, can actively engage in oversight on its own accord. The current board is chaired by Dr. W. Glenn Campbell, a noted educator who is director of the Hoover Institution at Stanford, California. The other 2 board members are Charles Myers, the former dean of the Stanford Law School, who is now in private practice, and Charles Tyroller II, who directs the Committee on the Present Danger, a bipartisan, nonprofit organization of distinguished private citizens devoted to sound foreign and national security policies. I would like to take this opportunity to lay to rest certain allegations that the board's level of oversight activity has diminished in recent years. The contrary is true. Indeed, records reflect that this board has been far more active and responsive in its oversight functions than predecessor boards. Documentation which establishes the accuracy of this statement is available and will be provided upon request. This brings me to an issue which is to be a focus of today's inquiry, the board's memorandum of September 12, 1985, which addressed alleged violations of the Boland Amendment by the National Security Council staff. In early August 1985, there were a number of press reports which claimed that Lieutenant Colonel Oliver North, a member of the National Security Council staff, was assisting the Contras in apparent violation of the Boland Amendment. These newspaper accounts prompted Representative Michael Barnes to direct a letter to Robert McFarland, then Assistant to the President for National Security Affairs, requesting information pertaining to any contact between Lieutenant Colonel North and Contra leaders during the period since the enactment of the Boland Amendment in October 1984. In light of these events, and in accordance with the board's policy, I undertook legal research and a factual investigation. As a result of these efforts, I concluded, 1, that the Boland Amendment was directed solely to the federal agencies making up the intelligence community. 2, that the Boland Amendment was not applicable to the NSC because it is not considered part of the intelligence community. 3, that the Boland Amendment might have applied to Lieutenant Colonel North if he was assigned to the NSC staff on a non-reimbursed basis from the Marine Corps. And 4, that the nature of Lieutenant Colonel North's activities, as portrayed to me, did not constitute a violation of the Boland Amendment, even if it applied to the NSC staff. My conclusions respecting Lieutenant Colonel North were based on an interview of Paul Thompson, then General Counsel to the NSC, a review of what I was told were all relevant NSC files, and a meeting with Lieutenant Colonel North. My legal research, undertaken prior to my factual investigation, focused on that portion of the Boland Amendment which made it specifically applicable to the CIA and the Department of Defense, and generally applicable to, quote, any other agency or entity of the United States involved in intelligence activities. I did not undertake research into the constitutional prerogatives of the President to conduct foreign affairs, whether the National Security Council, as an entity advising the President, came within these constitutional prerogatives, or the applicability of other laws. By joint resolution dated October 12, 1984, Congress authorized continuing appropriations in 9 separate appropriation acts which dealt with specific agencies of the federal government. The Appropriations Act, which dealt with the Department of Defense, expressly included the Boland Amendment. However, the legislation dealing with the Treasury, Postal Service, and general government appropriations, which includes the National Security Council, omitted the Boland Amendment, as did the 7 other appropriations acts contained in the joint resolution. It thus seemed clear that the Boland language did not apply to all appropriations specified in the joint resolution, nor was it specifically recited in the Appropriations Act, which included the National Security Council. Shortly after adopting the joint resolution, Congress enacted the Intelligence Authorization Act for fiscal year 1985, which incorporated the essence of the Boland Amendment and specifically listed 10 separate elements of the United States government engaged in intelligence and intelligence-related activities. The National Security Council was not listed. Accordingly, I concluded that the legislation appeared to establish that it was the intent of Congress to restrict the Boland Amendment to the Defense Department and the 10 enumerated elements of the intelligence community, and not to include the National Security Council. The legislative history of the joint resolution and the Intelligence Authorization Act also tended to show that the ambit of the Boland Amendment did not include the NSC, insofar as no statement by any congressman suggesting that the Boland Amendment applied to the NSC could be found. Nor could I locate any instance where Congress had limited the activities of the NSC since its inception in 1947. Finally, my conclusions were buttressed by the fact that members of Congress, scholars, and the press also concluded in 1985 that the Boland Amendment did not extend to the National Security Council. Contrary views were also expressed, yet Congress took no action to resolve the uncertainty. In conclusion, the Board concluded in September 1985 that the Boland Amendment did not apply to the NSC. I think that that was a fair conclusion then, and I think that that is a fair conclusion now. Thank you.
Thank you very much, Mr. Sciaroni. Questions will begin with Mr. Van Cleve.
Thank you, Mr. Chairman. Good morning, Mr. Sciaroni.
Good morning.
State your full name for the record, please.
Bretton G. Sciaroni.
You are the author, the principal draftsman of a September 12, 1985 legal memorandum sent by the Intelligence Oversight Board to National Security Advisor Robert McFarlane. Is that correct?
Principal draftsman, yes.
And that memorandum is found as Exhibit 9 in the exhibit book before you and the members. Is that correct?
That's correct.
And that memorandum concluded that the Boland Amendment did not apply to the National Security Council. Is that correct?
That's right.
The opinion also concluded that even if the Boland Amendment did apply to the NSC, Colonel North's activities as reported to the Board did not violate the amendment. Is that correct?
That is correct.
Mr. Sciaroni, what is your present age?
35 years old.
And you have served as counsel to the Intelligence Oversight Board since July 1984. Is that correct?
That is correct.
All right. You received a master's degree in international affairs from Georgetown in 1977, correct?
Right.
And a law degree in 1978 from UCLA?
That's
Is
true.
that correct? You held fellowships at the Hoover Institute and the American Enterprise Institute in International Relations. Is that correct?
That is correct.
You worked at the Arms Control and Disarmament Agency and then at the International Trade Administration before you came to the Intelligence Oversight Board, correct?
I did.
So you have extensive experience, both academic and professional experience in foreign affairs and national security issues. Is that correct?
That is correct.
Now, the Intelligence Oversight Board was established by executive order. Is that correct?
True.
And is a copy of the executive order which establishes that board found at Exhibit 1? That would be Executive Order 12334.
That is correct.
Okay. Now, the board consists of 3 members. Is that correct?
Right.
And the 3 current members are Dr. W. Glenn Campbell, Director of the Hoover Institution, correct?
Right.
Charles Myers,
Right.
correct? The former dean of the Stanford Law School, who is now a private attorney practicing in Denver. Is that correct?
That's true.
And Charles Tyroler, the Director of the Committee on the Present Danger, correct?
Correct.
And were these 3 individuals also the members of the board at the time of the September 12, 1985 opinion?
They were.
The members of the board receive expenses only for their service and meet 6 times a year with additional meetings as needed, correct?
That is correct.
The board issues approximately 10 opinions per year, correct?
On an average.
On an average. And they review the opinions before they're issued.
Every one.
And that would include, of course, the September 12, 1985 opinion.
Yes, sir.
And these opinions are issued based on decisions by the Intelligence Oversight Board as to what matters it should investigate, correct?
Right.
Because its principal function, as specified in the executive order, is to inform the President of intelligence activities that any member of the Board believes are in violation of the Constitution or laws of the United States, executive orders or presidential directives, correct?
Correct.
Okay, and this September 12, 1985 opinion was issued pursuant to that mandate, correct?
True.
I'd like to turn now to the circumstances that surrounded the drafting of that opinion, if I might. I take it that the September 12, 1985 opinion was written as a result of an investigation that you initiated on behalf of the Board.
That's true.
And when I use the word Board here, I'm referring to the Intelligence Oversight Board.
Right.
Okay. And this investigation was prompted by news articles which appeared in the late summer, probably early to mid-August of 1985, which alleged that a White House official on the NSC staff had had involvement with the Contras, which violated the Boland Amendment. Is that correct?
That is correct.
And I believe your counsel produced to the committee on your behalf a copy of a New York Times article dated the 8th of August, 1985, on the front page, which has the headline, "Nicaraguan Rebels Getting Advice from White House on Operations." Is that correct?
Correct.
And that article begins, "Rebels fighting to overthrow the Nicaraguan government have been receiving direct military advice from White House officials on the National Security Council. Senior administration officials and members of Congress have disclosed." Is that correct?
That's correct.
And the article continues, "Although some members of Congress say they believe the National Security Council operation has flouted the intent of legislation banning direct aid to the rebels, they add that they do not believe it violates United States laws." And the article continues, "If the President wants to use," and this is a quotation, "if the President wants to use the NSC to operate a war in Nicaragua, I don't think there's any way we can control it," said Representative George Brown, Democrat of California and a member of the House Select Committee on Intelligence. He and other members, Intelligence Committee members, said they had discussed the operation. Quote, "But," Mr. Brown added, "we haven't taken any formal action," unquote. Now, is that the type of article that prompted your investigation? And there were a series of similar news articles in that period of August 1985, weren't there?
There were a number. I've supplied them all to the committee.
That's right, and you've given those all to the committee, and I think the members of the committee can find many of those articles in the briefing books that they have before them this morning. And so the issue of White House involvement in direct military activity was raised at the time, wasn't it?
It was a prominent issue.
It was a prominent issue. It was before the public. It was before the Congress. It was before the press. No question about it. Is that correct?
Right.
And everyone understood that there was a question about the issue of NSC involvement with the Contras at the time. Is that correct?
No doubt about it.
And that's the kind of article that prompted your investigation.
Precisely.
Now, as I understand it, you began your work on this investigation by doing some legal research on the question of whether or not the National Security Council was covered by the Boland Amendment. Is that correct?
That is correct.
Okay. Let me back up just very briefly. As I understand it, shortly after these New York Times articles appeared, Representative Michael Barnes sent the White House a request for information concerning these allegations by a letter dated August 16th, 1985. Is that correct?
That is correct.
Okay, and as a copy of Representative Barnes's letter appears for the information of the committee as Exhibit 2. And if I'm not mistaken, Congressman Hamilton also sent a related request for information as chairman of the House Intelligence Committee to the White House shortly thereafter. Is that correct?
That's my understanding of, I think my inquiry was more prompted by Congressman Barnes' letter, which was reported in the press, and I think I later secured a copy from the NSC.
Okay. Now, again, to return to the beginning of your investigation, you began your work by doing legal research to establish the basic legal framework for the investigation. And at that time, after having done that research, you concluded that the National Security Council was not covered by the Boland Amendment. Is that correct?
Right, with a caveat attached regarding people who are detailed.
That's right. There's a footnote in the opinion, footnote number 5, that specifically discusses Colonel North's status as a detailee from the Department of Defense and raises a question about the coverage of the amendment with respect to him that is based on whether or not he was on reimbursed detail or not. Is that correct?
That is correct.
Okay. Now, I'm sure that I and the members of the committee will come back to the fundamental legal issue, but I want to move on then to the factual investigation that you did, because your opinion comes in two parts. Is that correct? First,
True.
there's a legal analysis, and then there's what I would describe as a fallback analysis, a factual analysis, which basically says, suppose that the NSC is covered by the Boland Amendment. Let's take a look at what actually is going on and see whether or not those activities would in some way offend the Boland Amendment. Is that correct?
That is true.
Okay. Now, in the process of pursuing that factual investigation, you met with then NSC General Counsel Paul Thompson. Is that correct?
I did.
And did you make an appointment to see Mr. Thompson?
I did.
Okay. And the purpose of your meeting was to determine what Thompson knew about these allegations. Is that correct?
True.
Now, I believe you've supplied to the committee a series of notes that you made during the course of this investigation. Is that correct?
Right.
And are those notes Exhibit 3?
They are.
These are handwritten notes that were prepared by Mr. Sciaroni at the time that he was conducting the investigation. Now, in the upper left-hand corner of the first page of these notes is a note that reads, NSC involvement, and then it says, 1, moral support while funds, and there's an arrow pointing down.
Right.
2, influence Ray atrocities.
True.
3, encourage political program.
Right.
And then it says March 1 San Jose Declaration, and then there's a line.
Right.
And it says no MIL period, and that word appears to be support.
That's true.
Okay. Now, is it your best recollection that these notations reflect a conversation that you had with Mr. Thompson concerning the activities of the NSC in general at this time?
Right. I think the top half of the page, which goes 2 more lines, would reflect the conversation that I had, notes from the conversation I had with the NSC General Counsel.
Okay. And so is it your recollection then that although Mr. Thompson indicated that the NSC was providing moral support and encouraging a political program, that it was not engaged in providing military support?
That's true.
Now, did you request that Mr. Thompson provide you with documents concerning the activities of the NSC at this time?
I did.
And did Mr. Thompson provide you with any documents during this meeting?
Yes, he pulled out of his file cabinet a stack of documents.
Okay, and can you indicate to the committee how large a quantity of documents Mr. Thompson provided to you?
To the best of my recollection, it was a stack of documents about 1 inch high.
Okay, and did you review those documents?
I did.
And do your notes reflect the results of your review of those documents?
Right. Again, on the first page of my handwritten notes, and then going over to the second page would be notes that I took while I sat in his office.
I see. So again, these are contemporaneous notes,
Right.
and they reflect the results of your review of the documents that Mr. Thompson showed you at the
Right.
time.
That's true.
And did you review all of the documents that Mr. Thompson provided to you?
I did.
Okay. Now, I'd like to ask you, Mr. Sciaroni, to review, take a minute and review exhibits BGS 4 through BGS 8. And I'd like you to look at each of these documents, and while you're doing that, I'm going to describe these documents generally to the committee so that they will know what the documents involve. For the information of the committee, exhibits BGS 4 through BGS 8 are documents that have previously been made exhibits before the committee during the testimony of Robert McFarland. These are BGS 4 was McFarland Exhibit 32, BGS 5 was McFarland Exhibit 33, BGS 6 was McFarland Exhibit 35, BGS 7 was McFarland Exhibit 36, and BGS 8 was McFarland Exhibit 37. Now, Mr. Sciaroni, I'd like to ask you to turn to BGS 4, if I might.
Are we going to take these one at a time?
Yes.
Okay.
BGS 4 is a memorandum dated December 4th, 1984, for Robert McFarland from Oliver North, subject assistance for the Nicaraguan resistance. And just generally, this memorandum reflects a meeting between Oliver North and, the memo says, Gaston Segur, and an official of what has previously been testified to be Country 4 at the Cosmos Club in Washington. And the memorandum refers to a shipment of arms which was intended for the Nicaraguan resistance, according to the memorandum, and which was coming from Country 4 to the resistance. The second page of the memorandum also refers to meetings, I believe, with officials of Countries 3 and 5 with respect to fundraising for the resistance. Now, I'd like to ask you, Mr. Sciaroni, this document is dated December 4th, 1984, so of course it was created well before you met with Mr. Thompson. Were you shown this document to the best of your recollection?
I was not.
And would you regard this document as relevant
Certainly.
to the inquiry that you were making?
Certainly.
Okay. Turning now to BGS Exhibit 5. This document is dated February 6, 1985. It's a memorandum from Oliver North for Robert McFarland. The subject is Nicaraguan arms shipments. And without going into a great level of detail, it refers to a ship, Manimbo, and describes as a series of options: seizing the shipment, sinking the ship, and so on. To the best of your recollection, Mr. Sciaroni, were you shown this document by Mr. Thompson?
I was not.
And would you have regarded it as relevant to your inquiry?
Absolutely.
Turning now to BGS Exhibit 7. Document dated March 16, 1985, a memorandum for Robert McFarland from Oliver North, subject to fallback plan for the Nicaraguan resistance. And this document contains, on the second page, a statement: commitment for another $25 to $30 million from the donors will be necessary for munitions in 1986, in anticipation that the $28 million requested in the intelligence budget is not approved. Once again, Mr. Sciaroni, to your recollection, were you shown this document by Mr. Thompson?
Which document are we looking at right now?
This is BGS Exhibit 7, dated March 16, 1985.
I was not shown this document.
And would you have regarded it as relevant to your inquiry?
Yes, I would have.
Turning now to BGS Exhibit 8. This is a document dated April 11th, 1985. It's a memorandum from Oliver North to Robert McFarland, subject FDN military operations. And this memorandum appears to have a fairly detailed accounting of expenditures and activities of the resistance and also includes as an attachment an accounting of FDN expenditures and outlays, including specifics on a series of weapons purchases. To the best of your recollection, Mr. Sciaroni, were you shown this document by Mr. Thompson?
I would not have missed a document such as this.
I'm sorry, I didn't hear you.
I would not have missed a document such as this.
Right, so your recollection is that you were not shown this document by
That's
Mr.
correct.
Thompson, right? And now I take it that your notes do not contain references to any of these documents, BGS Exhibits 4 through 8, do they?
I don't believe they do.
Okay. And to your testimony that any of these documents would have been significant enough from the point of view of your investigation that you believe that you would have reviewed such a document, made a notation concerning the document at that time. Is that correct?
Absolutely.
Now, at about this same time, you had a meeting with Colonel North concerning your investigation, did you not?
I did.
And I understand this was a very short meeting, is that correct?
Right. I went into his office late one evening to ask him about the allegations.
All right. And roughly how long would you say the meeting lasted?
Probably no more than 5 minutes.
Now, I understand that you asked Oliver North if there was any truth to the newspaper stories that had appeared. Is that correct?
That's correct.
And what did North say to you?
He said there was no truth to the newspaper accounts.
And did he say anything else?
Not to the best of my recollection. It was a blanket denial of all of the accounts of his either being militarily involved or fundraising.
So he denied that he was involved either in fundraising or in giving military advice. Is that correct?
That's correct.
Now, did you do anything else as far as a factual inquiry was concerned?
Not to the best of my recollection.
Okay. So you had by this time completed both a legal analysis and a factual investigation that you believed was sufficient to allow you to write an opinion for the board. Is that correct?
That's correct. When I visited both Commander Thompson and Colonel North, they understood who I represented, the mandate of the board to look into matters of legality, and the seriousness of the allegations that have been raised. I figured that those were the two most significant people at the NSC that I could talk to with regard to the allegations. I should also note, however, by late August, the National Security Advisor had also denied that Colonel North was involved in any of these activities.
Okay. And shortly thereafter, then, you prepared an opinion for the Intelligence Oversight Board. Is that correct?
That's correct.
And that opinion contained the results of both your legal research and your factual research. Is that correct?
That's correct.
And was that opinion reviewed by the board?
It was.
And do you specifically recall that the board members reviewed that opinion?
Yes, I do.
And that would include Dean Myers. Is that correct?
That would include Dean Myers.
So the opinion actually, when it was sent to Mr. McFarland, was an opinion of the Intelligence Oversight Board. It was not a personal opinion of yours. Is that correct?
That's true. The Oversight Board reviews everything that I do and makes changes invariably.
Okay. Now, a copy of the Intelligence Oversight Board opinion on plain stationery but otherwise identical to the IOB opinion was found in Oliver North's office. Are you aware of that?
I'm aware of that.
Can you tell the committee how it might have come to be there?
I really don't know.
Okay. Now, obviously, Mr. Sciaroni, by this point, you've had a chance to review the Tower Board report. Is that correct?
That's correct.
And you've also, I imagine, heard a good deal of the congressional testimony concerning the activities of the National Security Council. Is that correct?
Right.
Based on what you know today, and the matters that are matters of public record, would you alter the legal conclusions of the September 12th, 1985 memorandum?
You're talking about the first section, the legal
The first
analysis.
section, the legal section of the memorandum.
The only change that I would make would be with regard to footnote 5. I would have to determine whether Colonel North was in fact on a reimbursed and non-reimbursed basis. But in terms of the main thrust of the opinion, no.
So as to the main thrust, the conclusion that the National Security Council was not covered by the Boland Amendment, you would not alter your conclusion. Is that correct?
That's correct.
Now, for the benefit of the committee, I'd like to spend a few minutes reviewing with you some of the reasoning of your legal opinion. And what I'm going to try and do is to provide additional factual background that obviously was available to you when you wrote the opinion, matters that you refer to generally in the opinion, and some additional historical context. To begin, I'd like to ask you a few questions about the National Security Council itself. The Council was established in 1947 as an advisory body for the President. Is that correct?
That's correct.
And it consists of certain statutory members, including the President, the Vice President, the Secretaries of State and Defense, and other cabinet officers serving at the pleasure of the President. Is that correct?
That's correct.
And the staff of the National Security Council is considered part of the Executive Office of the President of the United States. Is that correct?
That's correct.
And the staff reports to the Assistant to the President for National Security Affairs. Is that correct?
That is correct.
And he is commonly referred to as the National Security Advisor.
Correct.
Therefore, a restriction on the activities of the National Security Council staff would be a restriction on the activities of part of the Executive Office of the President of the United States. Is that correct?
That is true.
Now, the NSC has been in existence for 40 years this year. Is that correct?
Yes.
Do you know of any legislation which significantly affects the authority of the National Security Council, which does so without mentioning the National Security Council by name?
I do not.
And do you know of any statute which has been passed since 1947 which has attempted in any way to restrict the actions of the National Security Council?
No.
Now, Executive Order 12333 provides in part as follows with respect to the National Security Council, does it not? The National Security Council shall act as the highest executive branch entity that provides review of, guidance for, and direction to the conduct of all national foreign intelligence, counterintelligence, and special activities and attendant policies and programs. Is that correct?
That is correct.
And that description of the National Security Council in that executive order is intended to make the point that the National Security Council serves as the executive branch coordinating body for national security and intelligence policy. Is that correct?
That is true.
Now, you were aware at the time that you wrote your September 12, 1985 opinion that if the National Security Council were covered by the Boland Amendment, that would raise substantial constitutional questions. Is that correct?
That is correct.
I'd like to ask you a few questions now about the Boland Amendment itself.
Right.
What type of statutory provision is the Boland Amendment? Is it an appropriations rider?
It is.
And where was it initially found?
In the appropriations for the Department of Defense.
In the Department of Defense appropriations for which were part of the continuing resolution for fiscal year 1985. Is that correct?
That is correct.
Okay. Now, would you please, for the benefit of the committee, read the text of Section 8066A of the continuing resolution?
During fiscal year 1985, no funds available to the Central Intelligence Agency, the Department of Defense, or any other agency or entity of the United States involved in intelligence activities may be obligated or expended for the purpose or which would have the effect of supporting directly or indirectly military or paramilitary operations in Nicaragua by any nation, group, organization, movement, or individual.
Okay. Now, we've said that the Boland Amendment is a provision of part of Title VIII of the Department of Defense Appropriations Bill. What is a continuing resolution, Mr. Sciaroni? Is it an omnibus appropriations bill?
It certainly was in this occasion.
And so it contained a series of individual appropriations bills stitched together and passed as one bill. Is that correct?
I believe 9 in number.
And do the provisions of one appropriations bill, such as the Department of the Interior appropriations bill, normally affect the operations of another department, such as the Department of Defense?
No.
So, in effect, the omnibus appropriations bill is a series of individual appropriations bills, and it is to be read that way unless it is clear that it is intended to be read otherwise, correct?
I believe there are general provisions that apply across the board, but the Boland Amendment was not one of those.
Okay. Now, if you turn to Exhibit 22 in your exhibit book, please. The first page of Exhibit 22 is the beginning of Section 101H of the continuing resolution for fiscal year 1985. And this is the provision of the continuing resolution in which the Boland Amendment appears. And it begins as follows: such amounts as may be necessary for programs, projects, or activities provided for in the Department of Defense Appropriation Act 1985. And it then continues to be effective as if it had been enacted into law as the regular Appropriation Act, and it then contains a title. And the title reads, "An Act Making Appropriations for the Department of Defense for the fiscal year ending September 30, 1985, and for other purposes. So this is the Department of Defense Appropriations Bill, correct?
Correct.
And the Boland Amendment is a rider to the Department of Defense Appropriations Bill. Is that correct?
That is correct.
Now, turning to the third page of that same exhibit, Mr. Sciaroni, you'll see that this is the page headed 98 Stat 1935. The Boland Amendment appears about in the middle of that page as Section 8066A of this Department of Defense Appropriations Bill. If you'd look just briefly at Section 8065, the preceding provision, that's a provision that relates to the Department of Defense, doesn't it?
That's true.
Now, if you would turn 2 additional pages to the page headed 98 Stat 1937 and look at Section 8067, which is the provision that follows the Boland Amendment. You have that in front of you?
Yes, I do.
And that's a provision that applies to the Department of Defense. Is that not correct?
That is correct.
Now, you've stated that there are in other sections of the continuing resolution provisions of general applicability. Is that correct?
That is correct.
Okay. Now, does the National Security Council receive any of its funding through the Department of Defense Appropriations Bill?
No, it doesn't.
Has it ever received, to your knowledge, any of its funding through the Department of Defense Appropriations Bill?
Not to my knowledge.
Therefore, if it was intended to impose a limitation on the National Security Council, part of the Office of the President, by using a rider to the Department of Defense Appropriations Bill, wouldn't it have been necessary to cross-reference this in some way to the Appropriations Bill, which actually provides the appropriations for the National Security Council?
Yes, it would have.
And was this done?
No.
Now, does the Intelligence Committee of either the House or the Senate have any jurisdiction over the National Security Council, to your knowledge?
No.
Have any of the intelligence authorization bills reported by either the House or the Senate ever purported to expressly limit or constrain the actions of the National Security Advisor or of the National Security Council?
No.
Both the Congress and the executive branch employ a concept called the intelligence community, don't they?
True.
And that term is defined in Executive Order 12333, isn't it?
It is.
And that order went into effect in 1981, correct?
Correct.
And Congress, both the House and the Senate, were consulted during the drafting of that order, weren't they?
To the best of my knowledge, yes.
Yes. So that both the House and the Senate can fairly be said to have been familiar with the definition of intelligence community. Is that correct?
Correct.
And that definition clearly omits the National Security Council, doesn't it?
It does.
Even though the National Security Council and its powers and activities are specifically discussed in the same executive order, correct?
Correct.
Now, the intelligence authorization bills of the 2 houses, which have been passed since the intelligence committees were created, purport to cover a list of agencies and entities, don't they?
Yes, they do.
And that list has never included the National Security Council, has it?
No.
And that list is substantially identical to the term intelligence community as defined in the executive order, isn't it?
True.
Is it fair to say, then, that the most logical reading of the term involved in intelligence activities, given the history of the National Security Council and the fact that Congress has never limited its activities by statute, given the usage of the term intelligence community and the fact that it clearly excludes the National Security Council, is it fair to say that the most logical reading of the term involved in intelligence activities is that it refers to those departments and agencies within the intelligence community as that term is defined in the order?
That is correct.
And I have one final line of questioning for you, Mr. Sciaroni. And these questions have to do with the relationship between the National Security Council's coordinating role and its operational role. At page 6 of your opinion, the opinion says, one can only conclude that successive acts of Congress, as well as the executive order, have not included the NSC in the intelligence community because it does not function as an operational unit. It is not by accident that the Intelligence Authorization Acts for the last 7 years did not list the NSC as an organization conducting intelligence or intelligence-related activities for which funds were being obligated. It was simply a recognition of the fundamental coordinating character of the NSC. It is a reasonable conclusion that the Boland Amendment was meant to apply to members of the intelligence community who carry out intelligence operations. Now, you were not saying in this opinion that the NSC has never had an operational role, were you?
No.
In fact, under several different previous administrations, the NSC has occasionally had operational responsibility, hasn't it?
It's a rare role, but it does occur.
But in fact, there are plenty of documented cases throughout a series of administrations where it's had that role.
That's true.
The point you were making in the opinion is that the NSC does not typically have such a role. Is that correct?
That is correct.
And it's your view that Congress, in adopting the Boland Amendment, wanted to eliminate intelligence and defense community support for the Contras. Is that correct?
That is correct.
And the Boland Amendment would clearly preclude use of the intelligence community and Defense Department personnel and infrastructure, both in the United States and in Central America, to provide military assistance to the Contras, correct?
Correct.
But this is quite different, is it not, than the idea that the Boland Amendment, without saying so, was also intended to reach the activities of the National Security Council and the Office of the President. Is that correct?
Very different.
Do you happen to know about what the total fiscal year 1985 appropriations for the entire National Security Council and its worldwide operations were, Mr. Sciaroni?
I do not.
If I said to you that they were under $5 million, would that sound about right to you?
That sounds right.
Isn't it true then that even if the Boland Amendment is read to exclude the National Security Council, its key purposes are clearly met?
Right.
No further questions, Mr. Chairman.
Mr. Niels.
Morning, Mr. Sciaroni.
Good morning.
I take it there came a time in August or so of 1985, perhaps September, when you conducted an investigation of Mr. North's activities.
That's correct.
And you began it by going into Mr. Thompson's office.
Well, I don't recall which I did first. I either chatted with Colonel North or Commander Thompson.
In any event, at some point in time, you went into Mr. Thompson's office.
I did.
And he showed you a stack of documents.
He did.
And it was about an inch high.
Yes.
And he told you that those were the documents which had been shown to the Hill.
That's true.
And I take it, according to your testimony, he did not show you Exhibits 4 through 8.
He did not.
Now, the committee has heard prior testimony that these documents were specifically identified by Mr. Thompson to Mr. McFarland as problematic documents.
I'm aware of that.
And Mr. McFarland made a list of the numbers on those documents.
That's my understanding.
But those documents were not shown to you by Mr. Thompson.
They were not.
So that you were unaware, I take it, of documents, official NSC documents, reflecting references to current donors who had contributed millions of dollars to the Contras.
I was unaware of that.
And you were unaware of references to efforts to recruit people to do sabotage for
That's
the Contras.
true.
And you were unaware of references to plans to sinking boats carrying arms to the Sandinistas.
That's true.
And you were unaware of references in the documents to people, third countries assisting us in getting end-user certificates to provide arms to the Contras.
I was totally unaware of that.
And you were unaware with documents showing that NSC officials had intervened with third countries in order to facilitate other arms provisions to the Contras.
That's true.
And indeed, Mr. Thompson told you orally quite to the contrary, didn't he?
He did.
Now, then you went in and had a conversation with Mr. North.
Right.
In his office.
Right.
And I take it you knew Mr. North.
I did.
You worked in the same building as Mr. North,
On the same floor of the old executive office building.
and you would bump into him from time to time,
Certainly.
and you would go down to his office from time to time.
True.
Contras was a controversial issue at that time,
Indeed,
And
it
he
has
would-
remained so.
and he was the point man on the Contras, and you got to know him,
That's true.
and you got to be generally friendly with him.
We were cordial.
And you went into his office in furtherance of your investigation, and you inquired of the truth of the reports in the press.
That's true.
And he said there was no truth to them at all.
That's right.
He didn't mention that he had recruited Richard Secord to provide arms to the Contras, for example.
I never heard the name of Richard Secord until the summer of 1986 when one of the evening news programs had a segment about a Mall aircraft that was being used in Central America that he had purchased.
And he didn't mention, for example, that he had in July or early August decided to have the money no longer go directly to the Contras, but to go to Swiss bank accounts under Secord's control.
I knew nothing of that.
And he didn't mention that he had solicited a contribution from Mr. Coors for a Mall aircraft.
He did not.
Now, you were aware, were you not, that there were tons of documents in North's office?
Certainly.
And indeed, you even asked Commander Thompson about that, didn't you?
I believe I did.
And you said, here's a little stack of documents. How about all those documents that are all over North's office?
Right.
And he said, well, those are North's personal documents, and all we have is the official documents.
That's my recollection.
Now, you didn't understand those personal documents to refer to North's family or something. You just understood they were not official documents.
I took them to mean that they were working documents that he used and not part of the official NSE document system.
But I take it when you talked to Mr. North, you didn't ask to review those documents.
No.
So you never saw, for example, correspondence with Robert Owen.
No.
I take it you eventually became to know a Robert Owen and to be a friend of his.
I am indeed a friend of Rob Owen.
But you weren't shown any documents, for example, going between Robert Owen and Colonel North referring to Steelhammer.
No.
Or any other documents
No.
going between them. And I take it the Intelligence Oversight Board is not truly set up to conduct large-scale investigations.
Right. We have an investigatory authority, but we do not have things such as subpoena power or ability to put people under oath.
So you need to rely to a considerable degree on the cooperation of people in the intelligence community.
That's absolutely true.
And it is important in order to get that cooperation to remain on good working terms with them.
Well, if there are members of the intelligence community, they are required by law to provide help in the course of our duties. The NSC is not part of the intelligence community, as has been pointed out. So in that particular case, I am dependent upon the goodwill of the officials, unless I had reason to believe that something was being hidden from me.
In any event, it would have been difficult for you to have said, Ali, I'm now going to have to review all of the files in your office.
That's true.
And you did not do that.
No.
And as a result, you ended up your investigation believing that the NSC had not raised funds or given military support or helped give military support to the Contras.
I had no reason to believe that.
And you wrote that down in your report as a conclusion, did you not?
That's true.
And it now appears that that was incorrect.
That is true.
And so that at least part of the report that you wrote ended up as a result of concealment of facts from you to be based on misinformation.
Well, I wouldn't choose to characterize it until you could hear from the other participants about why those things weren't shown to me.
Well, I'm simply asking you, sir, isn't it true that the conclusion was based on failure to communicate information to you?
True.
You didn't have the facts.
That's true.
And it was the incorrect facts in part upon which your opinion was based.
That's absolutely correct.
And indeed, you had one of the reasons, and I emphasize for the moment only one of them, but one of the bases for your legal conclusion was that the NSC was not an operational organization.
It's not typically an operational organization, that's true.
And you were not told at that time that it was in fact involved in an intelligence operation?
No, I was not told that.
And you would agree, sir, I take it, that covertly supporting a war in Nicaragua is an intelligence activity?
Could you rephrase that?
Covert support for the war in Nicaragua is an intelligence activity.
That would seem to follow.
And you were unaware of the fact that the NSC was engaged in such an intelligence activity?
Well, I don't know the truth of the documents that have been presented to me as part of the exhibit book, but if those facts are true, then that would definitely be support for the war in Nicaragua.
In any event, you were under the impression the NSC was not engaged in that particular intelligence activity.
That is true.
And I take it that you were aware that the National Security Advisor had so informed the Congress.
He had.
And he informed the Congress of that both before and after your opinion.
That's true.
And I take it you're aware that, for example, Elliott Abrams has said that these facts were concealed from him as well.
I wasn't able to follow his testimony, but I'll accept your characterization of that.
And I take it you're aware of the fact that in 1986, Oliver North told the Congress that he wasn't engaged in fundraising or military support for the Contras.
I'm aware of that.
And you're aware that the people of this country were told at the time that the Hassenfuss plane went down that the NSC was not involved in this particular intelligence activity?
I'm aware that there was denial that the CIA was involved. I'm not sure about the NSC.
We've heard evidence of that during Mr. Abrams' testimony. It's on the record.
Fine.
I take it in any event, to your knowledge, at no time did anyone tell Congress, did any official of the U.S. government tell Congress that the NSC was involved in raising funds or providing military support for the Contras during this time period?
I've heard no such thing.
Now, in addition, I take it you're not aware of any time when anyone told Congress that the NSC took the position that it could provide such support?
That's correct. Bud McFarland did testify that quite the opposite was true, that he thought that as a matter of policy, I believe, he decided that it would extend to the NSC. The application of the Boland Amendment, that is.
Now, Congressman Boland himself said on the told the House of Representatives, and you don't need to turn to this, I'm just going to read it for a moment to lead into a question, but he told the House of Representatives, and this is in BGS 12, Exhibit 12, immediately prior to the enactment of the Boland Amendment. He said, to repeat, the compromise provision clearly ends U.S. support for war in Nicaragua. And immediately thereafter, the House of Representatives enacted the conference provision that it had agreed to with the Senate. Now, that was a public statement, was it not?
Correct.
It's on the public record.
True.
And anybody who wants to can read it.
That's right.
And indeed, it was told to the members of Congress who voted for the Boland Amendment.
Right.
Your opinion, on the other hand, was secret.
True.
You classified it.
Right.
So now this is an interpretation of a law, publicly enacted law of the United States, and you classified it.
Right.
And that limited its distribution.
Right.
And indeed, the only person to whom you are aware that this opinion was sent was Mr. McFarland.
Right.
And Mr. McFarland doesn't remember receiving it.
Right.
And he disagrees with it.
Right.
Now, I take it you're not aware of anybody that ever relied on your opinion.
I am not aware that anybody ever relied upon that.
And indeed, North, instead of saying that his conduct was authorized by law, told Congress he wasn't doing it.
That's true.
And McFarland, instead of saying that the conduct was authorized by law, told Congress it wasn't happening.
That's true.
And indeed, Paul Thompson, the NSC lawyer, told you it wasn't happening.
That's true, too.
And Elliott Abrams has testified that he thought the Boland Amendment applied to the NSC.
I'll take your word on that.
Nobody ever told Congress about this classified opinion saying that the Boland Amendment didn't apply to the NSC, to your knowledge.
To my knowledge, no.
And I take it might be fair to say that North didn't want Congress to know that there was such an opinion.
I would have no idea about that.
Well, I'd like you to turn to what has been marked Exhibit number 28 in your book. It may not have a tab on it. You may have to look for it behind Exhibit number 26. Should be the last piece of paper. Should be marked VGS 28. It's a prof message, or two prof messages. In the upper right-hand corner, it says date and time 8/20/85. Do you have that in front of you?
Yes, I do.
Now, the second prof message is a note from Oliver North, and it reads as follows. Barnes' letter, I take it that's the letter from Congressman Barnes that inquires about NSC support for the Contras.
Excuse me, if he just had a chance to read these, he hasn't had an
Sure.
opportunity to review them at all.
Yes, sir.
Got a chance to read that?
Yes,
The second note refers to the Barnes letter, does it not?
it does.
And it says, it refers to the fact that the Barnes letter requests material on the subject of the North-Contra contacts. Is that correct?
Right.
And this is in August 19th of 1985. And it says, prior to your transfer of this action, I discussed the Barnes letter with Jim Michael, and he urges that we not jump too fast on this issue. And then it says, he shares my concern that our legal fellow is going to create unhelpful speculation, ray our intentions on this matter as he proceeds around town asking questions about the Boland Amendment and its legal legislative intent. Jim recommends, and I agree, that our response to the Barnes letter should be very quietly drafted by Jim, Paul Thompson, and a rep from Fielding's office. Regards, North. Now, our legal fellow, that's you, isn't it?
I have no idea.
But apparently, whoever writes this, who is Oliver North, doesn't want, he's afraid that if people find out that somebody's going to write a legal opinion saying that the NSC can do all these things, that Congress is going to find out they are doing them. Isn't that what that prof message shows?
I don't know who this prof message is referring to.
You've never seen this before.
No. I don't know Jim Michael either.
Well, I'd like you to turn back to the beginning of this exhibit number 26. I shouldn't say this exhibit, it's Exhibit 26, it's under the same tab.
Let me just add, too, that this is if this was referring to any work that I was doing, which I'm not sure that it does, it would be a misrepresentation because the memo merely stated that Boland Amendment didn't apply to the NSC. I was not discussing whether you could positively do anything. It was a very narrow opinion that said that that particular piece of legislation didn't apply to the NSC.
In any event, they seem to be pretty nervous about the idea that somebody may be announcing that it's legal to support the Contras.
Also, I'm not sure this would be me. Going around town would not seem to be me. I wasn't going around town. I was going around the building, I suppose.
Whoever it is, it apparently made them nervous
Right.
because they were afraid that that somebody would find out what they were doing.
It would seem to be the implication of that statement.
Okay, I'd like you to turn to Exhibit 26, which is a document found in North's files.
Right.
It has a cover letter from Vince. Is that Vince Canestraro?
I would assume so.
To Ollie, that's Ollie North,
There's no other.
attaching a copy of a document on the U.S. House of Representatives letterhead, which addresses the applicability
Excuse
of
me,
the-
do you know the date of the cover memo?
We only know that it was attached to this document.
Okay.
The document itself is dated August 8th, 1985, and it would appear that somebody from the Hill, or that Oliver North has obtained an opinion from somebody on the Hill that the Boland Amendment does apply to the NSC.
That seems to be the conclusion of this memo.
Yeah, it says at one place here, NSC is clearly a U.S. entity involved in intelligence activities subject to the Section 8066A prohibition.
Correct.
And that's the Boland Amendment.
That's right.
And Ollie already had that in his files, apparently.
Right.
And he didn't want anybody to find out that there was some other legal opinion that might lead to speculation as to what he was doing.
I wouldn't know about that.
And you have identified, I think, a document marked 9A, which is the copy of your opinion, which was found in Mr. North's office.
Right.
And that's the one that has the top part of the opinion cut off so you can't tell who wrote it.
Right.
Now, we don't know why that was done, but it certainly helps conceal the fact that there's some opinion in the White House
Right.
or in the old executive office building that the NSC is exempt from the Boland Amendment.
It does conceal that fact.
Now, I'd like to briefly address the legal issue that you addressed in your opinion. I think you've already told us that covert support for the war in Nicaragua would be an intelligence activity.
Right.
And I would like you to turn to Exhibit 27. Again, it's without a tab. It's sandwiched in between Exhibits 26 and 28. It is Public Law 97-377, and it's dated December of '82. And on the second page, I think you will see in Section 793 what has been referred to as Boland 1, the very first Boland Amendment way back in 1982. Do you have that in front of you?
Yes, I do.
Are you familiar with that provision?
That was prior to my time as counsel.
Did you happen to review it in connection with your writing the legal opinion you've been testifying about?
Because it predates it by several years, I probably didn't review that one.
Well, let's review it now. It comes in the, it's found in the Department of Defense Appropriations Act. You've already testified about the Department of Defense Appropriation Act. And again, it's one of these exceptions to the appropriation. And it reads, none of the funds provided in this act may be used by the Central Intelligence Agency or the Department of Defense to furnish military equipment, military and training, and so forth to the Contras in order to overthrow the government of Nicaragua.
Right.
Now, there are two things about that I'd like to focus on. One is it has the word, none of the funds provided in this act. And those are the only funds that that provision applies to, isn't it?
Excuse me?
Those are the only funds that that provision applies to, the funds provided in this act.
It would seem.
So it only applies to funds provided in the Department of Defense Appropriations Act. Is that correct?
That seems to be right.
And it also applies to only the two agencies covered by that act, namely the Central Intelligence Agency or the Department of Defense.
Right.
Now that is in marked contrast, is it not, sir, to the language of the Boland Amendment that you've been testifying about today?
Sure, because the subsequent one extended it to the rest of the members of the intelligence community.
Well, it does two things, doesn't it? First, it says, and it's up on that wall there, Section 8066A, and it says, no funds available to. Correct? That's a change in language, is it not? You see that language?
Oh, yeah.
That's in the very provision that was covered by your opinion. It says no funds available to.
Right.
It doesn't just limit itself to funds covered by this particular act. It says no funds available to. Is that correct?
Well, that's what it states, but it still is attached to the Department of Defense Authorization, or Appropriations Act.
I'm going to keep going.
Fine.
Then it also makes a change in the agencies to which it applies. Instead of being limited to the Department of Defense and the Central Intelligence Agencies, which are the ones covered by the that section of the appropriation statute, it says, or any other agency or entity of the United States involved in intelligence activities, doesn't it?
It does.
Now, I believe you said in your own opinion, and that's Exhibit 9, if you choose to refer to it, and I would address you to page 2 of your opinion, referring to the very language that I have just read from 8066A, you state, and I'm quoting from your opinion at the top of page 2, on the face of it, the NSC would appear to be an agency or entity of the United States covered by the amendment.
Right.
You do say that.
Right.
But you go beyond the face of the statute in your opinion, and you search for other methods of divining the intent.
Well, I go on to point out that the subsequent phrase, any other agency or entity in the United States involved in intelligence activities, is more or less a term of art which would imply the intelligence community.
And you say over on page 3, if the intent was to include the NSC, that could have been easily done.
Correct.
And you refer specifically to Congressman Boland.
I do.
And you say, if he had wanted the NSC to be restricted by the legislation, the specific prohibition could have been made clear in the legislative history.
Right.
And then over on Exhibit 12, we have a little piece of the legislative history.
True.
And indeed, it is a piece of the legislative history that comes out of the mouth of Congressman Boland. Is that true?
Right.
And he was the author and sponsor of the Boland Amendment.
Right.
And he had just been to conference with the Senate.
Mm-hmm.
And they had agreed on a compromise.
Right.
And he was explaining the compromise to the House of Representatives immediately prior to their voting on the Boland Amendment so that they could understand what it meant.
Right.
And he said on the second page of this exhibit, to repeat, the compromise provision clearly ends U.S. support for war in Nicaragua.
Right.
That's pretty clear, isn't it?
It's pretty clear to me.
And then he's asked a question by Mr. Livingston. Question, are there no exceptions to this prohibition? Mr.
Right.
Boland, there are no exceptions to the prohibition. That's what he said, isn't it?
He said that.
And then up above on the page, also in explanation, he says, it clearly prohibits any expenditure, including those from accounts for salaries and all support costs.
I think the relevant sentence is the one that precedes it. He states, let me make very clear that this prohibition applies to all funds available in fiscal year 85, regardless of any accounting procedure at any agency. Now the question becomes, what did he mean by any agency? Any agency in the U.S. government or any agency in the intelligence community?
But he says any agency. He didn't say any agency in the intelligence community, did he?
Was that implied?
That's just my question. That's what he said, isn't it?
He said
any agency.
He said any agency, and I took that to mean any agency in the intelligence community because of the two acts that it was subsequently attached to.
Now, if Mr. Boland had wanted to have the NSC covered, if he'd wanted to make sure that the President didn't find some other agency through which to conduct this intelligence activity, he could have done two things, couldn't he? Either one of two things. You want me to tell you what they are?
Yeah, well, that would be helpful.
The first, he could have listed every agency that he could think of that the President might conceivably use as a way of getting around the prohibition. He could have listed the EPA, the DEA, Customs, OMB, and every other agency he could think of that the President might conceivably use to support the war in Nicaragua, and including the NSC. That's one option that he had.
Or he could simply say no funds available to the U.S. government rather than limiting it to CIA, DOD, and members of the intelligence community.
Or he didn't say the intelligence community in the statute, sir. Or he could have, I take it what I said is true. That's one option that he could have followed.
Surely.
And another is he could use the words any agency engaged in intelligence activities, and I think you've already testified that covert support for the war in Nicaragua is an intelligence activity.
If it was he could have put it in a general provision that would apply across the board. Instead, it appeared in a Defense Appropriations Act and an Intelligence Authorization Act.
Now, quite apart from the Boland Amendment, The NSC can't do covert intelligence operations overseas without a specific determination by the President. Isn't that true?
Well, there are two views on that, as you know, Mr. Niels.
Well, you're familiar with Executive Order 12333.
I am.
And you're familiar with provision 1.8 thereof.
Which exhibit is that?
I'm sorry, that's exhibit number 14. It's also up on the wall, by the way, including specifically section 1.8 of it.
Right, I'm familiar with that.
And that provides that with respect to covert operations, and this is different than just collecting intelligence, is it not? With respect to covert operations, which are defined in the executive order as special activities,
Right.
no agency except the CIA can do them unless, and I'm reading from 1.8e, the President determines that another agency is more likely to achieve a particular objective.
Well, as you know from our discussion the other day, the alternate interpretation is that the purpose and effect of the executive order is to the members of the intelligence community, which are listed in the executive order. Now, I was not present when this executive order was put together, and so I don't know what agreements or interagency negotiations took place that might lend further definition to whether they're talking about all agencies or just specifically agencies of the intelligence community.
Well, the NSC is specifically mentioned in this executive order, is it not?
If I could finish, Mr. Niels, all I was going to say is that I don't know about the legislative history, so to speak, of the Act, but I would say that it appears on the surface to apply to any agency. I think that would be a fair reading.
So that your reading of this would be that the NSC cannot run a covert war in Central America unless the President determines that it is more likely to achieve that objective than the CIA.
Well, without passing judgment on whether the NSC was doing that, what I would say is that if a covert action, the purpose for a presidential finding, at least as a management tool inside the executive branch, would be to make sure that the policy is properly coordinated and that there's proper authorization. So therefore it makes sense that any agency should have a presidential finding to ensure that the integrity of the process.
And you would agree, again, the best reading of this provision, 108.1.8e, is that before another agency besides the CIA can do a covert operation abroad, the President must make a determination.
That would be the implication of that, right.
And I don't know if you're familiar with it, but at page Roman numeral 3-24 of the Tower Board, it states, and I quote the Tower Board report, "The President told the Board on January 26, 1987, that he did not know that the NSC staff was engaged in helping the Contras." And I take it, I guess my question is this, you're not aware of the President ever having made a determination that the NSC should take this operation over from the CIA?
That is true.
And I take it that in addition to the fact that it would require a determination by the President, it would require that there be reporting to the Congress.
Right.
And that is provided by Section 3.1 of Executive Order 12333.
Right.
And I take it in addition to that, it would be required that the finding would be in writing.
I know of at least a U.S. government document that would require all findings to be in writing.
And I take it this requirement that there be a finding, that it be in writing, and that it be notified to Congress would apply to covert operations conducted by the DEA, for example.
Excuse me?
It would apply to covert operations done by the DEA, for example.
Sure.
So that if the DEA were to conduct a covert operation to ransom hostages overseas, that would require a presidential finding in writing notified to Congress.
Right. With regard to the previous question, I should add the caveat that both the NSDD 159 and the executive order are executive documents, and of course if the President wanted to waive the provisions of those, since he is the person who issues those documents, he could do so. But I think your point still stands.
I have no further questions, Mr. Chairman.
We will begin with the principal questioners. We'll operate under the 15-minute rule. Mr. Hyde.
I understand I'm to follow Mr. Foley. How does it do that? Well, all right. Well, Mr. Sciaroni, we have conflicting opinions, don't we, on what the Boland Amendment means and to whom it applies. Is that correct?
I never said mine was the only opinion on this subject.
No, I'm sure not. I like your opinion, so I want to talk about your opinion.
Okay.
So I asked you if there are conflicting opinions. From as different lawyers, you get different opinions. Is that right?
That's true. It's been my experience.
Has there anything you've heard today or that you've learned that would change your legal opinion
No.
as to whether the Boland Amendment applies to the NSC?
Not at all.
Now, we've been told about Exhibit 12, where Mr. Boland took the floor, and in the discussion, let me see if I can find Exhibit 12. In the congressional record, he said something that I would say is extraordinary. Of course, Mr. Boland is my dear friend, and he's an extraordinary fellow. But he said, to repeat, the compromise provision, I'm trying to figure out what the compromise was. This seemed to be pretty one way here. The compromise provision clearly ends U.S. support for the war in Nicaragua. Such support can only be renewed if the President can convince the Congress that this very strict prohibition should be overturned. Now, I compared that language with the Boland Amendment, and I found a disparity. It seemed to me the Boland Amendment started naming agencies. Now, if they wanted all U.S. government support to be foreclosed, why didn't they say so? Isn't that a principle of legal construction, statutory construction, that if you want all agencies of government, including but not limited to the CIA, the Department of Defense, the National Security Council, wouldn't it have been simple to say that?
I think you make a good point. One of the problems with the language on the floor is that it seems to be broader than the statute as enacted. Of course, statutory construction does require going to look at the language that is issued, especially by the author of the provision. But I think that when you have language on the floor that is broader than the language in the statute yourself, you're constrained by the language in the statute.
That's the place you start, with the language of the statute. Now, the line of questioning that preceded my own would seem to indicate that the naming of the CIA and the Department of Defense was kind of idle. It had no point, because clearly what the intent of the Boland Amendment, as enunciated by Mr. Boland on the floor, was to halt in its tracks all U.S. support for the Contras in Nicaragua. But the Act didn't say that, did it? The Act says the CIA, it says the Department of Defense, or any other agency or entity involved in intelligence activities. Now, we are in a morass of ambiguity as to what what it means about an agency involved in intelligence activities. You interpret that to mean operational. Is that correct?
That's true, but there are some elements in the intelligence community that don't have an operational role. That's also true.
The President is not involved in intelligence activities. He's the ultimate consumer of what has been produced by those agencies involved in intelligence activities, correct?
That's true.
And the NSC doesn't go out and collect, analyze, and disseminate, which are the traditional functions of an intelligence operational agency. Isn't that correct?
Right.
Now, if the Boland Amendment wanted to foreclose all government funds, why didn't it simply say so?
Well, that's the first point, and the second point is that in the late summer of '85, there was widespread recognition that there was a controversy here, and that would have been another appropriate time to rectify this situation if there was a situation that needed to be rectified.
Why, there were statements, Mr. Sciaroni, from members of the Select Committee on Intelligence, liberal Democrat members, who said this clearly doesn't cover the NSC. And I cite George Brown as one example. Now, that was in August of '85, correct?
Right.
And that controversy has extended from then until now, has it not?
Indeed it has.
But has there been any effort on the part of Congress, dominated by the majority party that upholds the sanctity of the Boland Amendment in its many forms, to spell it out?
I'm aware of no effort.
That ambiguity is still there. Day after day, month after month, there's been no way. We could change it this afternoon, I'm sure, if we wanted to, and spell out, we mean the NSC, but there's been no effort to do that, has there?
No, there hasn't.
Now, we talk about your opinion being classified and not promulgated very much. Isn't it a fact that the controlling language on the Boland Amendment is not what Mr. Boland said on the floor? That was the House passing its version. You got another body here on Jenkins Hill called the Senate, and they passed their version. And these two versions come together in what's called a conference committee, correct?
Correct.
And what emerges from the conference committee is really the law. Isn't that correct?
That is true.
And isn't it true that the transcript of the discussions in the conference committee is still classified? Isn't that true?
I'm not privy to those sessions, and those records have never been made available to me.
Well, that may be so, but I'm informed by counsel that they are classified. Now, isn't one of the major problems here, and you didn't go into it because you didn't feel you had to address a very complex issue, was the constitutionality of the Boland Amendment? You didn't go into that at all, did you?
No, it wasn't necessary because the termination at Boland didn't apply.
Okay, now, but one of the big problems in this whole exercise is the fact that the Supreme Court, the law is, and I quote from U.S. versus Curtis Wright Export Company 299 U.S. 304, the President is endowed with plenary and exclusive power as the sole organ of the federal government in the field of international relations, a power which does not require as a basis for its exercise an act of Congress. Now that gives some problems to the congressional supremacists who want to tell the President what he can say, to whom he can say it, and to whom he can delegate responsibility to act for and on behalf of himself. The court says the President alone has the power to speak or listen as a representative of the nation, et cetera, et cetera. So now, given that fact, and without spending a lot of time rummaging through the books, would you say there's a question as to whether the Boland Amendment can bind and gag the executive department in the conduct of foreign policy in Nicaragua?
It certainly is a constitutional question.
What they can do, of course, is cut off funds. And they tried to cut off funds, and they put it in the Department of Defense appropriation, didn't they?
They did. Let me point out one other thing. You know, on the floor, Congressman Boland addressed the issue of all agencies, any agency. And it has occurred to me that if that was going to go across the board and apply to the NSC, it would apply to the NSC through the Executive Office of the President. Now, that would also mean it would apply to the President himself. And I think that that would have raised a major constitutional issue as to whether the President's own salary could be thus affected by a piece of legislation. If it was the intent to provoke a major constitutional debate, I think it would have been spelled out more clearly than that to see if, in fact, the Congress does have the power to affect the executive, through the executive office of the President himself.
Right. Now, you've heard that Mr. McFarland accepted that the Boland Amendment applied to the National Security Council.
I listened to his testimony very carefully, and it seemed to me that he was saying that it wasn't a matter of law, but a matter of policy, that he was choosing to apply it.
As I recall, his very words were, when Dante Fascell tells you don't spend any money on the Contras, that's it, that's the law.
I can appreciate his sentiment.
That's right. But that was a political judgment, certainly
Right.
not a legal one.
Right.
Now, you didn't shape your opinion, did you, to protect Oliver North or anybody else?
No.
You drafted your opinion on the applicability of the Boland Amendment to the NSC on the facts and on the law.
That's true.
Now, you are aware, are you not, that the Tower Commission viewed the Boland Amendment as very murky. And I quote from page Roman numerals 321, Congress, the result was an intense political struggle between the President and Congress over how to define U.S. policy toward Nicaragua. Congress sought to restrict the President's ability to implement his policy. What emerged was a highly ambiguous legal environment. That's the opinion, and I assume they're talking about the Boland Amendment, because they mention it. They say on December 21, Congress passed the first Boland Amendment, prohibiting the Department of Defense and the CIA from spending funds to overthrow Nicaragua or provoke conflict between Nicaragua and Honduras. Following year, $24 million was authorized for the Contras. On October 3rd, 84, Congress cut off all funding for the Contras and prohibited DOD, CIA, and any other agency or entity involved in intelligence activities from directly or indirectly supporting military operations in Nicaragua. Then the Tower Commission goes on and says the 1984 prohibition was subject to conflicting interpretation. On the one hand, several of its congressional supporters believed the legislation covered the activities of the NSC staff. On the other hand, it appears that Colonel North and Admiral Poindexter received legal advice from the President's IOB, Intelligence Oversight Board, that the restrictions on lethal assistance did not cover the NSC staff. Confusion only increased. In December 85, Congress approved classified amounts of funds to the Contras. That was a short time after Mr. Boland had said the U.S. government was out of the business of supporting the Contras. No money at all. For communications and advice, the authorization was subject to a classified annex negotiated by the Senate and House Intelligence Committees. An exchange of letters initiated the day the law passed, evidencing the extreme difficulty even the chairman of the two committees had in deciding what the annex permitted or proscribed. And we have excerpts up there of the chairman of the Senate committee saying one thing, chairman of the House committee saying another. So it is interesting that members of Congress and the NSC have to adhere to a law that is murky at best.
Let me just make a comment about that. I work a great deal with the attorneys from the Central Intelligence Agency, and over the last 2 years, they have had to go into a scramble, it seems, several times a year to try to figure out what the law is, what the intent of Congress is, and try to make sense of that operationally for them. And I have a great appreciation for the kind of headaches this has caused for them out there, because the Congress has changed its course numerous times, as you just elaborated.
I just have one more question, and I ask you this as a lawyer, Mr. Sciaroni. Can the Congress use its power of the purse to cut off, restrict, or amend the President's constitutional powers to be the supreme spokesman for American foreign policy, the sole operator? Can the power of the purse amend the constitutional powers of the President?
I don't believe so.
I don't think so either. Thank you.
Thank you.
Senator Mitchell.
Thank you, Mr. Chairman. Good morning, Mr. Sciaroni.
Good morning.
I guess
Mr. Sciaroni, as I understand it, prior to becoming counsel to the President's Intelligence Oversight Board, you had never practiced law. Is that correct?
That's true.
Indeed, when you applied for the job as counsel to the board, you were not qualified to practice law because you had not yet passed the bar examination.
That's true.
And as a condition of your becoming counsel to the board, you did take and pass the bar examination.
That's true as well.
So when you assumed your position as counsel to the President's Intelligence Oversight Board, it was the first time you had ever been employed as a lawyer in a legal capacity. Is that correct?
That's true. That's true.
And you had never before that conducted an investigation in a capacity as a lawyer. Is that correct?
That's true as well.
Now, I understand the staff of the Intelligence Oversight Board consisted of you and one secretary. Is that correct?
That's also true, and consultants are sometimes used.
Right. Now, as you've testified this morning, you conducted an investigation into the question of whether or not the Boland Amendment applied to the staff of the National Security Council.
Right.
Under the executive order establishing the board is to report to the President. Is
Right.
that correct?
That's true.
Now, your memorandum on that question is 7 typewritten pages long,
Right.
single-spaced, and it was addressed to Robert McFarland, who was then the President's National Security Advisor.
That's right.
Now, the memorandum makes no mention of the fact that on August 8, 1985, approximately 30 days before the memorandum, the President's principal spokesman said, and I quote, "No member of the National Security Council staff has, at any time, acted in violation of either the spirit or the letter of existing legislation dealing with U.S. assistance to the democratic resistance in Nicaragua." At the time you wrote your memorandum, were you aware of that statement by the President's principal spokesman?
Yes, I was.
And you did not feel that a statement by the President on the very subject which you were considering had any relevance to your inquiry?
By the time that the board issued that opinion, both the President, his principal spokesman, and the National Security Advisor had all rendered judgments that there was no violations of the Boland Amendment occurring at the NSC. I was aware of that, but I did not think that that should preclude a factual investigation by me.
The two are not mutually exclusive, are they?
Excuse me?
A factual investigation is not mutually exclusive of taking note of the fact that the President himself had made a statement on the very subject which you were advising him on.
Of the 3 administration statements stating that there was no violations of the Boland Amendment, none of those activities were occurring at the NSC, I took the National Security Advisor's statement to be the most substantive because he was, of course, Colonel North's immediate supervisor and would be apprised of what he was doing.
And that was the statement made by Mr. McFarland in a letter to Representative Hamilton on August 20th, 1985. Is that correct?
There was some press accounts in late August by the National Security Advisor,
Yes.
Robert McFarland. I was not aware of the Hamilton exchange with McFarland.
You were not aware of that?
I was not aware of it. That correspondence was not made available to me.
I see. So you conducted an investigation to inform the President on the question of whether or not the staff of the National Security Council was subject to the Boland Amendment, and you did not include in your memorandum any reference to statements made by the President and the National Security Advisor, and indeed the Department of State, on the very subject which you were expressing an opinion on. That's correct, is it not?
Yeah, it was a separate investigation.
I see. Do they not indicate to you that at that time, at least, the President, the National Security Advisor, and the State Department were of the view that the staff of the National Security Council was covered by the Boland Amendment?
I became aware of that around that time period, but again, much as the former National Security Advisor testified a few weeks ago, I took that to mean that it was a matter of policy that they were going to apply that, not as a matter of law. I didn't see statements of any legal analysis that was done, and I didn't know if they had or they had not, but that wouldn't preclude me from coming up with a separate opinion.
I don't suggest that they precluded you, but I must say that it is peculiar, to say the least, that in preparing for the President, through his National Security Advisor, a memorandum on the question of whether or not the Boland Amendment applied to the National Security Staff, that you did not even make note of the fact that both the President, who was the ultimate recipient of your opinion, and the National Security Advisor, who was the immediate recipient of your opinion, had previously expressed views on the very subject that you were rendering an opinion on. And indeed the Department of State as well, even though they were not the recipients of your opinion.
We don't work for the National Security Council staff, and if the President, if we had been shown, for example, the 5 memoranda in question, we would have had the opportunity to go directly to the President to express our concern about the course of action that was being taken. I think that the history of our board has shown that it is independent and objective, and by that I mean it is not tied to any other institution, either in the intelligence community or anywhere else.
If you were a public official and your lawyer was advising you on a question, would you like to have your lawyer, in the same opinion, remind you of prior statements you'd made on the very subject which the opinion dealt with?
I really don't know.
You don't? All right. Well, that answers the question. Mr. Sciaroni, as I understand your opinion, the National Security Council staff is not covered by the Boland Amendment because the National Security Council is not specifically identified either in the Boland Amendment itself or in Section 101 of the Intelligence Authorization Act of 1985. Is that correct?
That's correct.
So if an agency is listed, it is covered. And if an agency isn't listed, it's not covered. That's your opinion?
That's correct.
And in your opinion, it didn't make any difference what the employees of any agency were actually doing. If the agency is listed, they're covered by Boland. If the agency isn't listed, they're not covered by Boland. That's your opinion?
Well, it would stretch credulity to think that somebody in ag could do those kinds of things that the Boland Amendment tried to prohibit.
Well, supposing they did just that, Mr. Sciaroni, supposing employees of the Department of Agriculture, which is not listed in either of those pieces of legislation, engaged directly in the prohibited type of activity, that is intelligence activities, would they be covered by the Boland Amendment?
They wouldn't, but it's a highly unlikely situation. Operationally, agriculture
Have
is
you
not
been
set up to do
following
those
these
things.
hearings, Mr. Sciaroni?
Yes, I have.
Then there is very little that you could say that would qualify as highly unlikely. So your opinion, however, is, apart from the conclusion about highly unlikely, is that if the director of the Central Intelligence Agency did not agree with the Boland Amendment and wanted to avoid the Boland Amendment, he could have done so simply by transferring from the CIA to the offices and payroll of the Department of Agriculture those persons who are engaged in intelligence activities. And since they were then employed by an agency not specifically listed in the law, in your opinion, they're not covered by the Boland Amendment. Is that correct?
That would be very quickly become known that there was some operational entity at the Agriculture Department. I'm sure that the Congress would move to cut that off.
But until Congress moved to cut it off, in your legal opinion, they would not be covered by the Boland Amendment. That's what you're saying.
Well, that's true.
And so going down the list of agencies specifically included in either the Boland Amendment or Section 101 of the Intelligence Authorization Act, the CIA, the Defense Department, the Defense Intelligence Agency, the Army, the Navy, the Air Force, all they had to do to avoid the consequences of the Boland Act, in your legal opinion, was to transfer to the offices and payroll of the Agriculture Department or any other agency of government not specifically listed those persons engaged in that type of activity, and the Boland Amendment would not have applied to them. That's your legal opinion.
Sir, the operative words there is all they had to do, and I think that's a considerable amount for any operational intelligence agency to do, make a transfer such as that.
Having heard testimony about what Colonel North has done, Mr. Sciaroni, I'm asking you to limit yourself. Your opinion, as you've expressed it here today, is they could have done that and the Boland Amendment would not have applied to them.
Well,
You've testified to that, haven't you?
I would point out footnote 5, which does limit the organizations. You just simply couldn't transfer something to another agency. I pointed out that as long as those funds originated at the CIA or DOD, then certainly that would still fall under the prohibition.
But supposing they were on the payroll of another agency. They transferred them to the Agriculture Department, payroll and offices. Let me go on to, I think your answer is clear. Mr. Sciaroni, on October 10, 1984, Congress passed an Appropriations Act which took effect on October 12, which included what we know as the Boland Amendment. Is that correct?
That's correct.
On October 11th, the following day, 1984, Congress passed the Intelligence Authorization Act, which took effect on November 8th of that year. Is that correct?
That's correct.
In your opinion, did the Intelligence Authorization Act supersede the Appropriations Act?
It gave further definition to what was, and there are two pieces of legislation, distinct pieces of legislation, and one prohibited DOD specifically, and the other all members of the intelligence community.
My question was, did the Intelligence Authorization Act supersede the Appropriations Act?
I would say that it complemented it.
Did it supersede it? That's my question.
You mean in terms of coming second in time?
Did it supersede the Appropriations Act? That is my question.
I don't have an opinion on that. I don't think that they're two separate pieces of legislation.
Well, do you recall your deposition taken under oath 1 week ago today, Mr.
Right.
Sciaroni?
I was not using the word supersede in there in a strict sense.
Did you not use the word
I
supersede?
did.
You used it more than once, did you not?
Senator Mitchell, as you know, Mr. Sciaroni has not been given access to the deposition, except to the extent that he could visit the Capitol and see it. And therefore, he could visit the Capitol and see it, which he didn't have occasion to do.
Well,
so if you could refer to the specific portion of the deposition and let him read it, then he can respond to the questions.
On page 39, lines 22 and 3, you said the Authorization Act supersedes it.
I was groping for a word, and that may have been a poor choice of words.
So your testimony today is different from what it was last Monday. You do not now believe that the Authorization Act superseded the Appropriations Act.
We still don't have a copy of the deposition. And Mr. Sciaroni hasn't seen it since he was deposed a week ago.
But he acknowledges that he used the word superseded.
I'd like to have him read the deposition. Thank you. Well, what page was that, sir?
Page 39, lines 22 and 23, page 40, line 22.
Page 39.
I guess I'll ask you what you believe now, Mr.
That they
Sciaroni.
were
Do you
two-
believe that the Authorization Act superseded the
No, that was a poor choice of words. There were two pieces, separate pieces of legislation.
so that the Appropriations Act was not, in fact, superseded by the Authorization Act, was it?
That's true.
It remained in effect, did it not?
Right.
Right. And the prohibition contained in the Appropriations Act continued in force, notwithstanding the enactment of a later Authorization Act.
That's true.
All right, thank you. Now, Representative Hyde read to you a section from Supreme Court case known as Curtis Wright. As a lawyer, Mr. Sciaroni, do you know what the word dictum means when referring to legal opinions? Well, let me tell you what it means and then ask if you agree. Dictum, Mr. Sciaroni, is language in a legal opinion that is not essential to the decision and therefore is of no binding effect.
Yes.
You're not asking me for a definition, Senator.
Do you agree with that
Yes.
definition, Mr. Sciaroni?
Yes, I do.
And you're not aware as you sit there, are you, whether or not the provision read to you by Representative Hyde is or is not dictum?
I'd have to look up the opinion.
You'd have to look at the opinion, right. When you do so, I believe you'll find that it was dictum, that it was not relevant to the decision, and that it has no binding effect, as all dictum does not. I just have to say one more question, and then I'd like to make a comment. Is my time up, Mr. Chairman?
You take additional time, Senator Mitchell, because there was quite a break there while he
All
studied
right.
the...
Prior to,
Yes, prior to your preparing and providing to the board the opinion.
I don't believe I did.
So it was exclusively your work product.
Yes, sir.
And your entire investigation consisted of one meeting with Colonel Thompson, which lasted approximately 30 to 40 minutes, and one meeting with Colonel North, which lasted about 5 minutes.
Right.
Right. Well, the dictionary defines oversight, Mr. Sciaroni, in two ways. One is a failure to notice or consider an omission due to carelessness. The other is supervision with watchful care. I think it's fair to say that the executive order intended the latter, but it's hard to conclude that this opinion represented anything but the former.
Could I make a statement in response?
Yes, go ahead.
Where's the prof note? With regard to the investigation, I'd like to point out that the Congress investigated Colonel North's activities on more than one occasion, and they came up with the same result that I did, which was that he was not. Now, I agree that we have a small staff, but I believe in the integrity of the board and our function. And I would merely point out that the Congress has a great deal more staff and investigatory power than our small board does. I would like to read for the record a description, a prof note, which has been declassified, from an investigation that took place in the summer of 1986 of Colonel North's activities. And this, from the hearing so far, would indicate that the private benefactors were at the peak of their, I don't know, activities. And this prof note is with regard to the Hipsey interview of North, and it reads as follows. Session with success. Hamilton will entertain motion soonest to report unfavorably on resolution of inquiry and made clear believes Hipsey can turn aside future offers of similar resolutions. North's remarks were thorough and convincing. Hamilton underlined his appreciation to Admiral and to Bud for full cooperation offered by NSC. He restated that there were no facts uncovered by or known to Hipsey to substantiate the allegations in the resolution of inquiry or media reports of North's activities. And I bring this up not to be critical, but if the Congress, with a lot more manpower, can't come up with evidence, I'm not sure that a criticism of our board is right also.
Well, I'll make two comments. The first is that had you been seriously investigating this matter, had access to documents which simply were not available to the Congress, which were deliberately withheld from the Congress so as to create a misleading impression. And the second is, even assuming the validity of your point, the failure of one entity of government to perform its task is not a justification for another entity of government failing to perform its task. Thank you very much, Mr. Chairman. Thank you, Mr. Chairman.
May I be permitted to ask one follow-up question?
Mr. Hyde?
Thank you. Appreciate that. Mr. Sciaroni, when you go back to your office today, I'm going to ask you to do me a favor. Write Senator Mitchell a letter and ask him if he would please provide you with any Supreme Court case ever written that says anything different about the power of the president in foreign policy other than the dicta of the United States versus Curtiss-Wright export. And then when he responds, would you share that with me?
You don't
Thank
have
you.
to wait. I'll send you the Constitution.
You mean, Senator, that that the court is wrong and the court said something different from the Constitution? Do you really mean that, Senator?
Just have one further question and a comment. Mr. Sciaroni, did you discuss your opinion with any official of the Justice Department or any other legal officer of any intelligence agency of the United States?
Prior to?
Yes, prior to your preparing and providing to the board the opinion.
I don't believe I did.
So it was exclusively your work product?
Yes, sir.
And your entire investigation consisted of one meeting with Colonel Thompson, which lasted approximately 30 to 40 minutes, and one meeting with Colonel North, which lasted about 5 minutes.
Right.
Right. Well, the dictionary defines oversight, Mr. Sciaroni, in two ways. One is a failure to notice or consider an omission due to carelessness. The other is supervision with watchful care. I think it's fair to say that the executive order intended the latter, but it's hard to conclude that this opinion represented anything but the former.
Could I make a statement in response?
Yes, go ahead.
Where's the prof note? With regard to the investigation, I'd like to point out that the Congress investigated Colonel North's activities on more than one occasion, and they came up with the same result that I did, which was that he was not. Now, I agree that we have a small staff, but I believe in the integrity of the board and our function. And I would merely point out that the Congress has a great deal more staff and investigatory power than our small board does. I would like to read for the record a description, a prof note, which has been declassified, from an investigation that took place in the summer of 1986 of Colonel North's activities. And this, from the hearing so far, would indicate that the private benefactors were at the peak of their, I don't know, activities. And this prof note is with regard to the Hipsey interview of North, and it reads as follows. Session with success. Hamilton will entertain motion soonest to report unfavorably on resolution of inquiry and made clear believes Hipsey can turn aside future offers of similar resolutions. North's remarks were thorough and convincing. Hamilton underlined his appreciation to Admiral and to Bud for full cooperation offered by NSC. He restated that there were no facts uncovered by or known to Hipsey to substantiate the allegations in the resolution of inquiry or media reports of North's activities. And I bring this up not to be critical, but if the Congress, with a lot more manpower, can't come up with evidence, I'm not sure that a criticism of our board is right also.
Well, I'll make two comments. The first is that had you been seriously investigating this matter, had access to documents which simply were not available to the Congress, which were deliberately withheld from the Congress so as to create a misleading impression. And the second is, even assuming the validity of your point, the failure of one entity of government to perform its task is not a justification for another entity of government failing to perform its task. Thank you very much, Mr. Chairman. Thank you, Mr. Chairman.
May I be permitted to ask one follow-up question?
Mr. Hyde?
Thank you. Appreciate that. Mr. Sciaroni, when you go back to your office today, I'm going to ask you to do me a favor. Write Senator Mitchell a letter and ask him if he would please provide you with any Supreme Court case ever written that says anything different about the power of the President in foreign policy other than the dicta of the United States versus Curtis Wright export. And then when he responds, would you share that with me?
You don't have to wait. I'll send you the Constitution.
You mean, Senator, that the court is wrong and the court said something different from the Constitution? Do you really mean that, Senator?
Dictum in a Supreme Court opinion does not override the United States
It is
Constitution.
still a statement.
Never has and never will.
It is still a statement of the court, and there is no such Supreme Court decision, nor is there a textbook extant in the country that says that the President doesn't speak in a superior way because he has a national constituency. And if you can show me any different law than this, I would be very appreciative of it, and I will buy you dinner at a restaurant of your choice.
Well, I'll just, sorry, Mr. Chairman, we don't want to prolong this, but superior, which you've just used, is different from exclusive, which you used earlier. You've changed the substance of your argument in light of the events that intervened between your first comment and this one.
There is a doctrine called separation of powers that has not been amended by the Boland Act, I'm sure.
Senator Tribble.
Thank you, Mr. Chairman. Mr. Sciaroni, the Intelligence Oversight Board is established, and I read from the executive order, to enhance the security of the United States by assuring the legality of activities of the intelligence community. Now, the order says legality. What about wisdom or propriety? Do you see that as part of the mandate as well?
Yes, I do. Let me make a statement right here, because a former chairman of the board during the Carr years has criticized the current executive order, which did drop the word propriety. And our record shows that that word was dropped because they felt it was redundant. In other words, that laws of the United States, presidential directives and executive orders would cover that. I can also assure you that members of the intelligence community that report to our office have never changed their reporting standards, so that improprieties are reported to us as well.
So you'd be concerned then if actions were unwise or improper as well as illegal?
Absolutely.
Well, here I must say, even if it can be argued Boland did not apply to the NSC staff, one wonders how anyone would suggest these activities could be anything but a risk to the President and his policies. Let me go on to reading from the executive order. Section 2 spells out the responsibilities of the board. A, to inform the President of intelligence activities that any member of the board believes are in violation of the Constitution or the laws of the United States. How often has the board met with the President?
We meet at least on an annual basis, and if special circumstances require, then additional meetings are laid on.
So you meet with the President then at least once a year?
Right.
And what is the nature of that meeting?
We give him an annual report. It sort of quantifies what the activities of the board have been and the members of the intelligence community with regard to intelligence oversight for the preceding year.
Now, beyond those meetings, did you ever attempt to meet or otherwise communicate directly with the President?
Personally, no.
In your official capacity, representing the board in carrying out its responsibilities?
No, that would be the chairman's role.
And did the chairman do that, to your knowledge, on behalf of the board?
Other than usually when we meet with the President...
Other than your annual visits that you've described?
Sure, we have met with the President on other occasions.
All right, sir. Now, The second responsibility spelled out in Section 2 is to forward to the Attorney General reports received concerning intelligence activities deemed unlawful. Have you made such reports available to the Attorney General?
Yes, but let me add a caveat there. By the time I became counsel of the board, I think that the intelligence oversight system had developed to such a point that usually when we get word of an illegality or potential illegality, they are usually reported, invariably reported at the same time to the Attorney General.
Has the board during your tenure made such reports to the Attorney General?
There's only been one case so far as I know.
All right, sir. Now,
But when reports are forwarded to us, notation is always made by the originating agency that the Attorney General's office or the Department of Justice have been notified.
Now, Section E sets forth the responsibility to conduct such investigations as the board deems necessary to carry out its function. How many investigations have you and the board carried out?
Well, that would be a difficult question to answer because in my line of work, I'm not sure I could define the word investigation. There could be a full-blown investigation which would require my undivided attention for a multi-week period, or it could be something as simple as a newspaper item in the morning paper which would require me to pick up the secure line and call a responsible official in the intelligence community to find out if there was any substance behind the story.
How would you describe your August '85 inquiry?
I would say that
Was that an investigation?
it was not it was an investigation, right, but it's not as comprehensive as some that I've pursued.
So how many times have you carried out investigations that rise to the moment of your August '85 inquiry or above?
I'd have to think about that. That's hard to quantify.
Well, perhaps you can submit that to the record, for the record then.
I'll be happy to do so, and I would like to point out that the level of activity of this board has been much higher than previous boards. For example, the Defense Department, the Assistant for the Secretary of Defense for Intelligence Oversight, has confirmed that the level of requests for information during my tenure as counsel have been in 1985 23 and 1986 22, and in 1987 11. Now those 3 years are more than the entire Carter years put together and by an order of magnitude.
All right, Ms. Sciaroni, let's move on and focus for a moment on the August '85 inquiry.
Right.
You indicated you talked to Commander Thompson and to Colonel North.
Right.
And you asked Thompson, is this all? And Thompson said yes, except for what's in Ollie's personal files. Now, did you ask Commander Thompson what it was to be found in Colonel North's files?
He had made a distinction with regard to the memoranda that he was showing me. He said, first of all, that it was what the Hill had been shown, or been made available to the Hill, Capitol Hill. And he made a distinction between Colonel North's working papers and documents and things that had gone into the NSC, the system that had left Colonel North's office, I suppose.
I don't understand what you've just said. Were you led to believe that what remained in Colonel North's personal files were not relevant to your inquiry?
I was led to understand that those were not being made available because they were his working papers. I believe a legal distinction was being made.
Oh, I see. I see. So you knew then that you weren't receiving all the relevant information?
No, that's not what I said.
Well, it certainly sounded like that's what you said. You said that documents were being withheld for some legal reason. Working papers. That sounds like something akin to executive privilege. What are we,
no,
as it applies to the
personal
Congress?
papers, what he was currently engaged in working on.
All right, well, let me tackle this another way. We now know, do we not, that it wasn't all?
We do indeed.
All right. Under the law, are there any situations where you can be denied access to all relevant information when you ask for it in attempting to carry out your responsibilities?
Well, here's a distinction that needs to be made. If you will look at the executive order on intelligence, you'll see the members of the intelligence community that have to report to us, the inspector generals and the general counsels. The NSC is not listed there. So this investigation was an anomaly of a sort insofar as the NSC does not have a reporting requirement to us. Therefore, I was relying upon the goodwill of other officers at the White House to show me what was available and help me in my investigation. The hook upon which the investigation was launched was the fact that there were allegations of illegal activities. Now, if I had reason to believe that there were illegal activities going on, then I certainly would have gone to a higher level.
I understand, but you say then you had no responsibility to investigate the activities of the NSC, but you were doing that?
I have authority over, the board has the authority to investigate illegal intelligence activities. But we don't have the same kind of leverage with regard to the NSC as we do with the members of the intelligence community who have by law to report to us, and that's in the executive order. They don't have any choice about that. Now, if I had reason to believe that there was an illegal activity going on at the NSC, certainly
you would have reported to someone else.
I would have gone to the chairman immediately, to the full board, and we would have either gone to the National Security Advisor or the President.
All right, let me ask you this. Under the law as you understand it, in your activities with other intelligence agencies, can they say no or withhold documents when you request those?
No.
Did you say the NSC could because they really don't fit the definition of intelligence community?
If I had reason to believe there was something improper or illegal going on there, then I would have certainly pursued it to the full extent.
Did you pursue it with Oliver North when you talked to him? Did you ask him about those documents, about their relevance to your inquiry?
About the documents in his office?
Yes, those that you knew had been withheld.
No, I had already gone where I either had or was going to go over his head to a responsible officer at the NSC, that is the General Counsel, to secure that.
Sciaroni, let me ask you this. Is it institutionally possible for you to do your job of undertaking investigations? You tell us that you have no staff but for a secretary. You have no subpoena power. You basically stand alone. How can you secure the information that's necessary to carry out the mandate of this executive order?
Well, as I suggested in my opening statement, the system of intelligence oversight, as it has developed over the years, requires a reporting up so that there is a multi-tiered system of people in the intelligence community that gather illegalities or improprieties, things that happen, and they report them up to us. And they do this on a regular basis. And that is the integrity of the system is not dependent upon a huge staff at the top. It's dependent upon the entire system doing its job, and that's required by law. They have to report those things up the chain of command. They ultimately come to rest in our office for review and perhaps action.
Well,
now, let me say one other thing.
Sure.
It may be, I mean, you do have a point, though, and it may be a proper time to review whether the board should have something like the power to put people under oath or subpoena power. I mean, that's a valid point, and we're going to be reviewing that at the White House.
I think it's a matter that ought to be pursued, even at this late date. Let me ask you about the executive order. It says nothing about legal opinions, advisory legal opinions. What was the basis of authority for undertaking wide-ranging legal opinions?
Well, I wouldn't say they were wide-ranging, but it's the nature of the office. I mean, we look into matters of legality in the intelligence community, and I think that would be a natural outcome, is to forward memoranda to the President or his National Security Advisor. And what I should point out here, it has not come up so far, is that in the Reagan administration, the Reagan White House, it's been more decentralized, and so that most of the memoranda that we produce would go to the National Security Advisor, not directly to the President. We do have the authority to go directly to the President, as it states in the executive order, as you just pointed out. However, the way that this has typically functioned, at least in the time that this board has been around, is that the reports are made to the National Security Advisor in his role as the advisor to the President for National Security Affairs, not as the head of the NSC staff.
Not finding anything in your mandate about legal opinions, let's still move ahead. Why would you issue legal opinions to the National Security Council? By your own definition, The NSC is not part of the intelligence community.
Well, as I thought I just pointed out, we don't send forward memoranda to the NSC as the NSC. We send them to the Assistant to the President for National Security Affairs as the representative of the President.
Now, has the President ever read any of your memoranda?
I assume that he has.
Have you ever received a response to any legal opinion that you have offered?
Not in my tenure.
Doesn't that make you pause and wonder whether anyone's really listening?
Well, it's for our job to issue the opinions, and what they do with those opinions are their business.
How many have you issued, Mr. Sciaroni, and the board?
I can't say for sure how many the board has issued, but again, I think that it's about 10 memoranda a year. This is not the only focal point of what we do. I mean, we have to conduct, we have an active intelligence oversight inspection agenda. So I go out and inspect units in the field, either in the United States or abroad. I mean, there's a variety of activities I engage in, so I just don't sit around writing legal memoranda all day.
I understand. But when you issue legal memoranda, they are reviewed, are they not, and approved by the board?
By the entire board, sure.
So you and the board are issuing these opinions then, and it's your testimony there are about 10 a year?
Well, the board issues them, and that's a rough estimate that I came up with. I've never counted
How many prior to the September 12th, 1985 legal opinion?
I really wouldn't hazard a guess. I don't know.
Would you provide that information for the record, please?
Surely.
Now, I'm troubled by the fact that you're issuing legal opinions to the very agencies that is your job to oversee. Your job, as I understand
I don't think
it,
that's correct.
All right, let me share my concern and then put it to rest, if you will. Your job, as I understand it, is to be a watchdog. But doesn't the taking of trips with CIA, DOD personnel to show the flag, as you indicated in your deposition, the issuing of legal opinions compromise your independence? Doesn't it make you a partner and a participant rather than a disinterested commentator on intelligence activities that you're intended to be?
I don't believe so at all. I really think it's an asset for me to go out in the field, because the people that I typically go out with will be people that have similar responsibilities down the chain of command from the President's Intelligence Oversight Board. The people that I travel with are people from the offices of General Counsel or Inspectors General of the various units that are in the intelligence community.
What about the issuing of legal opinions as activities are contemplated? Doesn't that make you a part of the process rather than someone who stands back at arm's length, passing on the good judgment and propriety and legality of these activities?
No, I mean, I don't see that at all. The fact is that the board is independent and objective, and by independent and objective, I mean we don't have any institutional basis in the intelligence community at large. The fact of the matter is that none of us have intelligence backgrounds, and you know, some people may view that as a negative, but I think that the purpose for the board is to protect the rights of the American citizenry and making sure that there's no illegal activities that transpire. The issuance of opinions, I think, is totally proper, because those opinions are intended for the President, not for members of the intelligence community.
All right, sir. My time has passed. The chairman said he'd give me at least a moment or two more. Let me ask you very quickly, what was the response of the board to the newspaper articles in the August 1985 time frame, which set forth that there may have been some possible illegal activities? Was the board involved in your inquiry?
I always clear any investigation that I do, at least of that nature, with the board ahead of time.
Did you have a meeting with the board and report to them your findings?
We met in September. The very day that opinion was issued was the day that we met and considered that.
Did you spell out at that time the totality of your inquiry, the 5-minute meeting and the 30-minute meeting?
Sure, they understood all of that.
And they didn't raise any further questions at that time?
Well, it seemed adequate at that point in time. I'd ask the questions and I'd gotten the answers, or so I thought.
Should the board be more engaged in this process?
Well, they are unpaid individuals, and you may be making a cogent case for expanding the staff, to be sure, but these are three overseers who are distinguished citizens in private life, and they have their own areas of interest that they pursue.
All right, Ms. Sciaroni, I thank you. Mr. Chairman, let me just say in conclusion that as an attorney, I can assure you, Mr. Sciaroni, that none of us sitting here would really wish to have our research and writing held to the scrutiny that yours has been. You found yourself in your first legal position in a tough place, dealing with very complex issues. I know that you're an honest and conscientious man, and I wish you well. I must observe, however, that once again we see a situation where the checks and balances, they're such an important part of our system, the safeguards, didn't work or were not permitted to work. And I only wish here the board and its counsel had been more seasoned, more independent, and more vigilant. Thank you, Mr. Chairman.
Chair will advise members that we'll conclude the morning session after Congressman Foley questions. Chair recognizes Congressman Foley.
Good morning, sir.
Good morning.
You testified that none of the members of the board have any intelligence community experience. Is that correct?
I think there might be one exception to that, but generally that's true. They don't come from the intelligence community.
Nor do they, in fact, have any experience in the intelligence community work. Is that right?
So far as I know, that's correct.
And you don't have any yourself.
That's true.
And were you ever involved in writing legal opinions on legislative acts prior to your service with the board?
I can't recall that I was.
Did you ever write one before the September 1985 opinion that you've described?
None comes to mind.
So this is the first time in your legal career that you ever wrote an opinion regarding a legislative act?
Perhaps outside of law school.
Outside of law school. Did you, in fact, not take the bar exam for 5 years after your graduation from law school?
No, I did take the bar exam.
You graduated in 1979?
Right.
And you took the bar examination in 1984?
No, I didn't pass the bar in California.
You failed the California bar exam?
Right.
Did you take any other bar examinations that you failed?
DC, and I failed DC as well.
You failed the DC bar exam. What bar exam did you pass?
Pennsylvania.
Were you a resident of Pennsylvania at that time?
No, I wasn't.
Did you subsequently work in Pennsylvania, or at that time were you working in Pennsylvania?
No, it's a common trait among people in Washington to go up to Pennsylvania to take the bar exam, because if you score very well on it, you can immediately wave into DC.
So you took the bar exam in Pennsylvania as an easy way to get admitted to the DC bar?
Right.
I congratulate you on your candor.
Thank you.
When you became employed by the Intelligence Oversight Board, do you know how you were recommended for this position as counsel?
I believe that what transpired was that I knew the predecessor, and I understood he was leaving, and I submitted my resume.
To whom did you submit it?
I believe to the board. I sent it into the board.
Did you know any of the members of the board?
No.
And as far as you know, you were selected out of all the possible applicants because of your abilities to do this kind of work?
You'd have to ask the board members, but I believe my national security background was what recommended me for the job.
Your national security background being what again, please?
Well, I had been a public affairs fellow at the Hoover Institution, the American Enterprise Institute for Public Affairs, or Public Policy. I had served at the U.S. Arms Control Disarmament Agency and the International Trade Administration at Commerce Department. I had written articles and such in that area.
Did you have any intelligence community oversight or scholarly interests at those previous employment?
Not directly,
positions?
more having to do with the intelligence product rather than the process.
When you conducted the investigation that you say you conducted in August of 1985, you say that that was the first investigation that you conducted as a lawyer. Is that correct?
Excluding the investigation on the Taiwan manual, which had transpired in the fall of 1984.
And you considered this question that had arisen about U.S. activities in support of the Contras as being a serious and important matter for the board to investigate?
The articles were quite prominent in August of 1985.
It was a major issue, was it not?
It was.
And you considered that it was important for the board to involve itself in this matter?
I thought so.
And that's why you undertook this investigation,
Right.
which you considered to be one that required serious and thorough examination? Would that be fair?
That's fair.
Did you think you gave serious and thorough examination to the question?
I believe I did.
As a result of having spoken to two people, one for no more than half an hour and another for 5 minutes, you consider that was a thorough investigation?
The charges that had been leveled were general in nature, and once I had asked the questions about what Colonel North's activities were and had been given answers, I had no reason to doubt them, especially considering the fact that...
You asked the consul of the NSC, Commander Thompson,
Right.
to give you information regarding these allegations. And is your testimony now that he gave you inadequate and incomplete information?
That would appear to be the case.
Do you believe he misled you?
You should ask Commander Thompson.
I mean, what
why
do you
he-
believe? I'm asking you if you wish to state your opinion now. Do you believe now that he knew that that information was incomplete and gave it to mislead you? Gave you inadequate information to mislead you?
Sir, I wouldn't care to characterize. You ought to put the question to him why those those memoranda weren't shown to me.
In other words, you, at this time, knowing that you were given inadequate information by Commander Thompson, are unwilling to characterize as to whether he gave such inadequate information to you deliberately?
I have my personal views on that, sir.
Well, that's what I was asking for, is your personal view.
Right.
You don't care to give it?
I really wouldn't.
With respect to Colonel North, the person who you asked about his illegal activities in this 5-minute investigation in his office, do you believe he told you the full truth?
It would appear not.
You believe he deliberately misled you?
These are questions that we should hear from Colonel North about why he denied that he was doing these activities.
Well, I assume you know that he knew what his activities were, and he told you at the time that he was not involved in any illegal activity.
Right.
And you took his word for it and went back and wrote a report based on that.
You don't consider that another official is not going to tell you, answer your
How do
questions
you
precisely.
investigate another official if the investigation consists of asking him if he did anything wrong and taking his word when he said he didn't?
Both Commander Thompson and Colonel North knew what the mandate of the board was. I have to believe they understood the seriousness of my coming to ask them questions about activities, alleged activities out of the NSC.
Did you ever talk to anybody in the press that was making these allegations?
No, we don't have, we typically do not have any relations with the press.
Do you ever ask for have any consultation with anybody in the Congress about it?
We don't typically, with this appearance today being the sole exception, don't typically have any relations. We don't have any reporting requirement at the Congress.
What I'm trying to drive at, sir, is what is your concept of an investigation carried out by an oversight board charged under law with investigating illegal activity by intelligence and related agencies? Is your concept of that sort of investigation and oversight to ask them if they're doing anything wrong and to accept without question their assertion that they're not doing anything wrong and ending the investigation at that point?
No, I asked specifically whether he was engaged in giving military advice, whether he was out doing fundraising. I mean, the point of the matter is that the press stories at that point in time had Colonel North making trips to Central America, had Colonel North meeting with Contra leaders, with Jack Singlop. Now, I knew he was doing all those things. The question is, what was the content of those meetings or those trips?
Did you ever talk to General Sinlov, for example?
No, sir.
Ever make any contact with him?
No.
Would that be a reasonable thing for an investigator to do if you were investigating the relations between Oliver North and Jack Sinlov?
Well, I clearly wish I had now.
Well, in retrospect, wouldn't you fairly say that you didn't conduct any kind of an adequate or serious investigation of this matter?
No, that's not true at all. I discussed with the individuals the constraints imposed by law. They gave me every reason to believe that they understood what those constraints were and they were acting within the bounds.
But your testimony is that except for asking them if they had violated the constraints of law, you spoke to no other person, in or outside the government, made no effort to check their assertions or to discover any additional facts that might relate to this matter. Is that fair?
That's a fair statement. And I also reviewed the files.
And you reviewed the files that were given to you.
Right.
But you didn't go beyond the files that were given to you.
No, well, I had no particular authority to go beyond. They assured me that everything was...
Did you ask Colonel North for any of the files that you were told by Commander Thompson he alone possessed?
No.
Did you discuss it with him?
No, it was made clear to me that those were Colonel North's personal files.
By Commander Thompson, but
Right.
you didn't ask Colonel North that, did you?
It's true.
How do you know that Commander Thompson's information was correct? Wouldn't it be normal to ask Colonel North if those files were his personal files or not? So, in any way, you didn't ask them. You didn't inquire about the files, and there was no basis that you had then of knowing whether you were in possession of all the relevant information in the files.
Well, my investigation was probably as thorough as the one that had been conducted on the Hill.
You keep coming back to references of what was done on the Hill and what was done by your predecessors. We're asking you what you did in your position, charged by law with the responsibilities that you had. And you are insisting to us in your testimony today that as counsel and chief investigator of the Oversight Board for Intelligence, appointed by the President, that you thought you conducted a thorough and serious investigation of this matter when you spoke to Colonel or Commander Thompson for half an hour and Colonel North for 5 minutes and didn't go beyond the assertions made by either one that they were innocent of any wrongdoing, and didn't talk to anybody else, even people you knew were associated with them in the allegations, and didn't look at any files except the files that were given to you, and didn't inquire whether there were any other relevant files. Is that your testimony?
Well, at that point in time, I thought that I was going to an objective colleague, Commander Thompson, a legal colleague of mine at the NSC.
Well, let me ask you then, in view of what you've testified to and your experience, do you think the Intelligence Oversight Board is in a good position to discover illegalities committed by intelligence agencies? Unless those are previously admitted by the agencies themselves?
I think that we're an integral and essential part of the whole system of intelligence oversight, and we rely heavily on the people
An
down below.
integral and effective, or an
Essential.
integral and ineffective part of that overall part? That's what I'm trying to reach. Do you think that the Intelligence Oversight Board performs any activities that are useful in discovering illegalities committed by intelligence or related agencies?
Well, sir, I would point out that I was possibly the first person to warn Commander Thompson and the NSC of the existence of Colonel North's activities, or at least my suspicions concerning his activities in Central America.
If you were suspicious, I come back to the question, why didn't you go farther in your investigation?
Oh, I'm talking about a year later.
Oh, a year later, I'm sorry. You weren't suspicious at this particular time.
I became suspicious over time.
Let me go back to the question I just asked. Do you think that the Intelligence Oversight Board is a good mechanism of providing oversight for illegal acts committed by agencies if those acts are denied by the agency and not admitted by them?
It is an effective part of the oversight for the intelligence community. Do you think you were effective in this case? No, I was not.
Do you think the board was effective in this case?
Certainly not.
When you address your reports, do you address them to Mr. McFarland or whoever is the National Security Advisor?
Typically, although some do go directly to the President.
Some go directly to the President, but most are not even addressed to the President. Is that right?
Most are not addressed to the President. That's correct.
Where in the executive order does it mention the National Security Advisor?
As I explained earlier, we have the executive order states that we do report directly, but in the management system of this White House, we go through the National Security Advisor.
The assumption is that even though you're an Intelligence Oversight Board, that the National Security Advisor is the person you should report to, even though not mentioned in the executive order that defines your responsibility.
That has been the way the system has been set up.
And do you assume that you have responsibility for oversight of the National Security Council?
Only if I have
Staff,
reason to
let's say
believe.
the staff.
Only if I have reason to believe that there's something illegal, there's an illegal intelligence activity going on.
And that's why you conducted this so-called investigation
That's
in
right.
August of 1985. Do you, as a result of your activities, have any view as to whether there should be any changes in the law with respect to the oversight functions of intelligence agencies, including the National Security Council?
At this point, it is a moot point because the new National Security Advisor, Frank Carlucci, has announced that there's not going to be any intelligence operations out of the National Security Council.
So as long as we have the word of the National Security Council advisor, I don't mean this to be any besmirching of the present incumbent or past incumbents, but as long as we have the word, then that's sufficient in your judgment to take care of oversight responsibilities?
As one official put it to me after this thing had blown up late last year, the problem in this case wasn't a failure of the system, it was a failure to use the system. The system was there, it evidently was circumvented.
As far as the Intelligence Operations Oversight Board is concerned, we don't really need this as long as people just obey the law. Is that your testimony?
No, I don't think that's true at all. I think that it's important for intelligence operatives in the field to understand that there is an entity at the highest level of government that's concerned with professional, good intelligence operations, and that's one reason why I do go out in the field as I do.
I think it's important that they know that that agency is an agency that's vigilant and capable of discovering any violations of law if they occur in the intelligence community and bringing them to the proper authorities' attention.
They're certainly aware that that has happened.
Not in this case, however, correct?
We were unfortunately precluded from doing our job in this case.
Thank you.
The committees will stand in recess until 2 o'clock, at which time we'll begin under the 5-minute rule with Mr. Sciaroni. You ready to go, Dick? Yes, sir. The joint hearings of the Select Committee will come to order. We begin this afternoon under the 5-minute rule with further questions to Mr. Sciaroni. The Chair recognizes Mr. Cheney.
Mr. Chairman, I'll be very brief. I just have a brief statement, I think. In the interest of fairness, Mr. Sciaroni was rather heavily chastised this morning by my good friend and colleague, Mr. Foley, for not pursuing more aggressively the investigation of the press stories about Colonel North's involvement in support for the Contras in 1985 and 86. I think it's important for the record to show, Mr. Chairman, that the two Intelligence Oversight Committees of the House and Senate, with a total staff of some 60 people and the power to compel testimony and subpoena documents and witnesses, were also aware at that time of those allegations, did hold meetings and interviews with Colonel North, Mr. McFarland, and others, and also saw fit not to proceed beyond that initial series of interviews. And I think in the interest of fairness, the record ought to point that out. Finally, Mr. Chairman, I think the key point that's been made today is the legal analysis by Mr. Sciaroni that the Boland Amendment did not apply to the NSC. or to the NSC staff, and we've not yet heard that refuted. Mr. Chairman, I'd yield back the balance of my time.
Thank you, Mr. Chairman. Ms. Sciaroni, I don't really want to talk about the opinion very much. I think we've talked about it this morning. Everybody has their own view. I happen to think the opinion's probably incorrect, but people can disagree on that. I'm more interested in the board. This is a board that's created by executive authority, executive order. It is not a statutory board. Am I correct?
That's correct.
And looking at the executive order, it's kind of interesting as to what you all are supposed to do. It says you shall inform the President of intelligence activities. You should forward to the Attorney General reports received concerning intelligence activities the board believes unlawful, review the guidelines, review the practices, conduct the investigations deems necessary, and then whatever you find, if you don't report to the Attorney General or under that part of this order, you report to the President. The fact is that this board has no line authority whatsoever over anybody. Isn't that correct?
Well, it has the members of the intelligence community, the inspectors general and the general counsel, do have the obligation to report, and this is in section 4. If I could read that.
I have it in front of me. It says they provide you information so you can carry out your responsibilities. I repeat, you do not have line authority over those people. They are required by the President of the United States to supply you with information, but you have no authority to direct their activities.
That's true.
That's all I'm getting at. I don't want to fudge this issue any more than it's already misunderstood by the American people. This board has no line authority. There are people watching this all over the country wondering, what is this board? This board was set up by President Carter and then President Reagan, and the purpose of the board is to review and inform. And as a matter of fact, there is one section here that I believe was put in there very deliberately. It says you ought to forward to the Attorney General reports received concerning intelligence activities that the board believes may be unlawful.
True.
Not are unlawful, may be unlawful. You were never expected to have an investigatory arm, Mr. Sciaroni. I mean, you may do very cursory investigations, but let's be honest. How can one lawyer and one secretary and a part-time board investigate anything diligently? They can't, can they?
Well, sir, we can try.
Now, Mr. Sciaroni, I'm not talking about in some make-believe world. I mean, let's get down to cases here. I'm not criticizing you. You didn't write this. I'm just trying to get before this hearing what this board's all about. If you see a real problem, you send it to the Attorney General, correct?
That's true.
All right, let me ask you a question. You said, I think you may be correct, that you were the first person to notify Thompson, Commander Thompson,
right,
of possible illegal activities of North.
Right.
You testify that to this morning, correct?
Yes, sir.
Now, nowhere in this entire enabling executive order does it show you with any responsibility to the National Security Council.
Well, let me rephrase that. I did not know that Colonel North was conducting any illegal activities, but I thought that I suspected that he was probably engaged in a course of activities that would not redound to the benefit of the President.
Why didn't you report that to the Attorney General? That is exactly what paragraph B asks you to do. It doesn't say that you have found probable cause, Mr. Sciaroni. It simply says that if you have any reports concerning intelligence activities that may be unlawful, you ought to report them to the Attorney General, who of course would report them to the FBI, and if that had been done at the appropriate time, we might have got to the bottom of this a long time ago. Why wasn't that done by the board, if you know?
Yes, sir. I'm not referring to the September inquiry that I did with regard to the Boland memo. I'm referring to October of 1986. And at the end of that month is when I came to the belief that Colonel North was involved in activities to an extent I hadn't previously appreciated. I did not know that there was anything illegal being done. I went to the NSC's general counsel, reported my concerns to him. I then, the next week, the chairman of our board was in town. I reported my concerns to him as well. And unfortunately, the day that I reported my concerns to the chairman of the board is the day that a Lebanese newspaper reported on the McFarland trip to Tehran, and we were very quickly subsumed with the then pending problems with regard to the Iran situation.
Well, as far as that issue is concerned, that is correct. But the fact is that you're not an investigatory body. You're not staffed to do so. And what you ought to do if you think there's unlawful activity is turn it over to people who know how to investigate. Isn't that true, Mr. Sciaroni?
Perhaps that's what we would have done if we'd had time.
Yeah. Now, let me just, one last point. My time is up. You know, I really had a hard time following your answers to Senator Mitchell. And I want to just make sure I understood what you said. Is it your position currently, because you are still counsel to that board, so we have some interest in this, is it still your position, to use Senator Mitchell's analogy, that if the Department of Agriculture or the EPA carried out a chapter and verse covert operation, that because the Boland Amendment does not caption them, they would not be covered?
Well, first of all, I would never counsel such a course, but second of all, if the legislation had read any U.S. government funds
I'm not
whatsoever.
asking you for a legal explanation. I've heard it. I just want to understand if I understand your
The Boland
legal
Amendment
opinion.
didn't apply to the Agriculture Department.
So to make it even more probable, because the Agricultural Service is kind of far-fetched, if a president of the United States with a Boland Amendment type statute went to the U.S. Marshal Service, who has a lot of capability with undercover people and do a lot of interesting things, and they have a lot of capability, and said, we can't get this done because this amendment covers these items, you do it, then if you were advising your oversight board, you would say, as long as the Marshal Service wasn't captioned, then they could do it. That's your legal opinion.
Again, that legal opinion was very narrow. It just said it didn't apply to the NSC.
So that is your legal opinion?
As unlikely as that might have been, yeah.
Did you ever read Dickens, Mr. Sciaroni?
On occasion.
You ever read Oliver Twist?
It's been quite a while.
Well, do you remember Mr. Bumble? Well, I just want to tell you this because it's good for everyone to understand, the American people watching this, about our laws and how we make them. He said, if the law supposes that, Mr. Bumble, the law is an ass, an idiot. Now, this Congress assumes, Mr. Sciaroni, that when it passes a law, that an outrageous, blatant attempt to subvert the law will be recognized by the courts for what it is, because courts always recognize attempts to subvert the law. This is not a contract between adversaries. This is the intent of the United States Congress. And I just want to tell you, Mr. Sciaroni, that I think your opinion on that issue is just dead wrong. Thank you, Mr. Chairman.
Mr. Carter.
Thank you, Mr. Chairman. Mr. Sciaroni, this morning much was made of the fact that your legal credentials were not what some people would have them to be, but it's my understanding that one of the people that were members of the Intelligence Oversight Board was Charles Myers. Is that correct?
That is true.
And Charles Myers is, or was, the dean of Stanford University Law School.
Yes.
He was educated and got his Juris Doctor at Columbia University.
I believe so.
He was a professor of law at Stanford University for a period of time.
Right.
He was president of the Association of American Law Schools.
That's right.
Did he review your legal opinion with regard to whether the Boland Amendment covered the National Security Council?
He did indeed.
Did he agree with that opinion?
Excuse me?
Did he agree with that opinion?
Yes, he did.
So can I take it from your answers that the weight of the authority as to whether that legal opinion that was drafted by you I think we can conclude that it not only has the weight of your legal analysis, but the weight of the analysis of Charles Myers as well.
That's true.
Mr. Sciaroni, earlier this morning, much as well was brought out about the fact that your investigation into the factual circumstances of the Oliver North's involvement in these operations in Iran and Nicaragua was less than thorough. Do you remember the line of questioning?
I do indeed.
The question I have is, do you believe that your memorandum relies on those factual circumstances, or is it really a question of law rather than a question of fact?
Well, it was a question of law, except for where footnote 5 comes into play.
I understand your testimony, but with respect to whether Oliver North told you the complete truth or not, your memorandum stating in essence that the Boland Amendment does not cover the National Security Council would be the same irrespective of the factual circumstances.
That's true.
So we're dealing here with a question of law and not really a question of fact.
In the main, yes.
If the facts were, in other words, if you received a complete and candid disclosure from Oliver North as to his activities, your basic statement and legal analysis, agreed to, of course, by Charles Myers, would have been the same.
That's true.
And that would have been the fact that the National Security Council was not covered by the amendment.
That's right.
You obviously recognize the fact that not all attorneys have that view.
Oh, there's a great difference of opinion on that.
Do you think there's a difference of opinion where reasonable minds could differ?
I do.
There was an indication earlier this morning during the testimony that during the time the first Boland Amendment was passed, there was a significant debate that you were aware of as to whether that covered the National Security Council.
There was such a debate.
So it appears by the debate that was raging inside your department and particularly among members of Congress was that reasonable minds could differ as to the interpretation of the Boland Amendment.
That's true.
If reasonable minds can differ, and if Congress recognized that reasonable minds can differ as to whether it applied to the National Security Council, don't you think it was incumbent upon the Congress, if they had a strong view, to clarify that position by redrafting the amendment?
Yeah, I think that would have been, clarity is always to be desired in legislation, and I think that one thing that I would have preferred to say to Senator Rudman is that, again, to get back, if that prohibition was government-wide, it would also apply to the Executive Office of the President and therefore to the President himself, and I think then you have a major constitutional issue joined. I think that if that was the intent, to join that issue, not just the NSC but the President himself, then we should have had that debate in 84 or 85.
Thank you. No further questions.
Senator Cohen.
Thank you, Mr. Chairman. I was going to ask Senator Rudman if he could clarify his observations, but I think we'll have to let it speak for the record, Senator Rudman. He was a bit ambiguous in his assessment of the law on this point. But Congressman Cheney made an observation. He said that not only were you under this particular impression, but also the House and the Senate Intelligence Committees. The fact of the matter is the Intelligence Committee, at least the one in the Senate, doesn't have the power to compel NSC advisor or employees to come to the Hill, does it?
I don't believe it does.
Does it have the power to subpoena documents held by the NSC?
I don't believe that the Senate does, no.
As a matter of fact, the President was exerting executive privilege to those documents, was he not?
I wasn't there, but that's probably, probable.
Well, what took place, as a matter of fact, is we talk about you sort of walked in to that office and you indicated you felt that they knew how serious it really was when you came in to conduct an investigation. It was almost as if you're sort of Matt Dillon walking into the office, but the fact is you have sort of empty holsters because you can't compel them to do anything.
That's true. I don't have subpoena.
In effect said here's a 1-inch stack of documents which we've made available to the members of Congress, and that's all you're getting. The rest of these are private documents, right?
Right.
Personal documents. And
Or documents that aren't relevant.
documents that aren't relevant. You went into Colonel North's office, and you found his office was filled with documents, wasn't it?
Indeed, he had filed cases out in the corridor filled with paper as well.
Right, but they said this is what you're getting because that's all Congress is getting. Now give us an opinion on that, or make your opinion on that.
They said that they were producing the relevant documents for my review.
But you didn't go to Oliver North and say, I want to see the other documents, did you?
I had, well, first of all, he had several portfolios, so not all of those documents would be relevant. But in a practical sense, I don't think that I would probably still be sitting there. I think your staff can attest to how much paper Colonel North accumulated. I think I'd probably still be sitting there pouring through those documents.
Well, that's what they did to Congressman Barnes, said, come on down, don't bring any staff who can stay here. You might have 10 roll calls that day, but we're willing to let you sit here all by yourself for the next 10 weeks if you want to go through the documents.
I understand that, sir. I wasn't a party to that.
Right. But you went to Oliver North and you just, in essence, said, say it ain't so, Ollie.
No, I went to Commander Thompson because as a person higher up the chain of command, he would have access. I wouldn't simply rely upon Colonel North providing this.
But you said you went to Colonel North, you asked him whether he's engaged in anything illegal.
I asked him if he was engaged in the course of activities described in the newspapers.
Right. In your experience, have you ever known any individual that you've confronted or anybody else has confronted and saying, are you doing anything improper? And they've said yes?
I can't recall such an occasion.
No, I can't recall it either. Mr. Chairman, I just have an observation to make about a sort of pattern that has taken place here of catch-22 problems. On the one hand, we have the argument being made that don't include the NSC into intelligence, the definition of intelligence agencies, because it simply coordinates information and simply serves as an advisor to the President on intelligence gathered by other agencies. So don't, Congress, touch the NSC. That would be an improper thing for Congress to do. And then when the NSC is excluded from the Boland Amendment by lack of a specific reference, Congress is then chastised for its omission, saying even Congress didn't include the NSC after we are constantly told don't touch the NSC, it doesn't engage in intelligence activities. So that's one of the catch-22s that we find ourselves confronted with. Secondly, we have a situation in which incomplete, misleading information is given to counsel such as Mrs. Sciaroni, leading him to a conclusion, and then his legal opinion is cited for justification for continuing the activity, saying we've got an opinion here. It's okay, it's legal. Secondly, we have incomplete, misleading, or false information presented to the intelligence committees, and then the intelligence committees are then cited to corroborate the fact that the CIA or other intelligence agencies aren't engaging in anything wrong. And that has been a pattern throughout these hearings, and the reason of your testimony, I believe, Mrs. Sciaroni, will amply demonstrate that is consistent with what has been going on for some time. You have been precluded from having access to information, and then your opinion is cited for a justification for what is going on. That was wrong. You were deceived. We've been deceived. And it's no justification to say when you come here that the Intelligence Committee came to exactly the same conclusion. Thank you, Mr. Chairman.
Mr. McCollum.
Thank you, Mr. Chairman. Mr. Sciaroni, I think there are a couple of things that I've learned from your testimony that I think need to be at least put into some perspective today, a little bit. One of them, it seems to me, is very clear. We ought to be thankful that somebody down there in your shop at least had the gumption to raise this issue and to look at it and to offer an opinion, because nobody else did. Now, there were other attorneys, I think, that probably were down in the White House or around in the area, but you're the only one who offered an opinion, if I'm correct. Am I correct?
Frankly, sir, that thought has crossed my mind as well. You have a White House counsel's office, you have an NSC general counsel, and if they were too busy, they had a Department of Justice to get an opinion from. I don't know why my opinion was the only opinion.
Well, it doesn't make sense to me, but I'm thankful at least you gave an opinion. There was one down there somewhere. I wish there were others. Secondly, we've heard a lot about the question of the policy involved, and obviously the issue of the legality and why people were motivated to do this, that, or the other is intricately involved in the policy decision to use the NSC or for Colonel North to do some of the things he did, whether he thought about the law or not. And I think most of us listening to the testimony over the last few weeks have to conclude, whether we're Republicans or Democrats or whatever our persuasion, that the idea of doing all of this in secret wasn't such a hot idea. You said that pretty much today yourself, but that's not a legal question. The strange part is that in making the decision, yours was the only opinion floating around, and wasn't apparently a whole lot of reliance on a legal basis to make the decision to proceed in secret or public. My personal thoughts are that there wasn't anything, having listened to you, likely that would have been legally wrong with the President going out using the NSC to raise money, do it publicly, not do it secretly, and that the real problem we've got today with all of this and why we're having so stretched out a hearing on this portion of the Iran-Contra affair is simply because nobody really did look at this thing legally, and they proceeded to do things secretly, and they proceeded to fool Congress occasionally after the fact, or at least mislead, as some of my colleagues have paraphrased. That's really a tragedy in this whole affair that we've gotten to this point. I think that's unfortunate. But I would like to point one thing out in listening to what you've said today. You've just testified a couple of minutes ago to my colleague, Mr. Corder, that you believed reasonable men could differ as to their interpretation of the Boland Amendment and its applicability to the National Security Council, for example. And I think you've also testified earlier that while you didn't address the constitutional question, that there certainly is a question of, even if it were to apply to the NSC or be interpreted to apply, there's a question of constitutional application, whether it's valid to tie a president's appointed staff in this fashion. Is that not correct?
That's correct.
And but in constitutional interpretation, in your experience, I'm sure, I'm an attorney, it seems to me I recall this, Supreme Court generally and other courts look to trying to resolve ambiguities first, and if something's too ambiguous, they generally rule it doesn't apply and never go to the constitutional question. Isn't that true?
Yes.
I'd just like to read one quote to you about something that seems to me equally ambiguous as the Boland Amendment from very long ago. Justice Douglas, in an opinion in the early 1970s in United States versus Huddleston, which is 415 United States Supreme Court 834, referred to Caligula's practice of printing the laws in small print and placing them so high on the wall that the ordinary man couldn't receive a fair warning of whatever was written there. And what I think is interesting about that might better be paraphrased in the writing of a historian on Caligula's practice when he said, quote, "When taxes of this kind, the kind that Caligula had been proclaimed but not published in writing, inasmuch as many offenses were committed through ignorance of the letter of the law, he at last, on the demand of the people, had the law posted up, but in a very narrow place and in excessively small letters to prevent the making of a copy." That is from the Lives of Julius Caesar by Suetonius, published in 1932. I think the point is well made. If we're going to publish laws in this Congress, we ought to write them very clearly instead of in such small print or posting in such a very narrow way that people can't understand them or read them. Don't you agree?
Yes.
Thank you very much. That's all I have to ask.
Senator McClure.
Thank you, Mr. Chairman. I want to follow up just a moment on a rather narrow issue area that was raised earlier, and I do it only so that we won't be misled. Senator Mitchell had talked about whether or not it was possible to go to the Department of Agriculture, and Senator Rudman had indicated, again, had followed up on that point. I think Senator Cohen said something about the fact that Senator Rudman was not very precise, not very positive in his statement. Certainly he was more positive than he was precise in one respect, and I say that with great respect to my colleague, because there's one thing that's been overlooked, and that is whether the Boland Amendment applies to the NSC or applies to the Department of Agriculture is not the whole point as to whether or not it's legal. You could determine, indeed, that the Boland Amendment did not apply, but that doesn't necessarily mean it's legal for them to do it. I suspect nobody thought to make it illegal with USDA because nobody ever thought of the USDA being involved in covert activities. But I think to a degree nobody had ever thought of the NSC being involved in covert activities either, because it hadn't been done before. I think we ought to be careful when we talk about whether the Boland Amendment reaches it, and we conclude that it does not, that automatically means therefore it's legal for them to undertake the operation. And I take it your your opinion was not directed toward the question of whether or not NSC could legally involve itself in covert operations. It was whether or not the Boland Amendment applied to it.
I've attempted to make that point today, yes.
You said in your testimony earlier that you were a friend of Rob Owens. Is that correct?
That's true.
How long you known him?
I met him first in late 1985.
After you had joined the government?
Yes.
Is that a personal acquaintance?
I was introduced to him because he was involved in the Nicaraguan humanitarian assistance program, and I met him perhaps once 6 months later, and then at the latter part of 1986 I got to know him quite well.
And is that a personal relationship?
It is.
Is that such a close personal relationship that would in any way color your professional judgment as concerning the legality, the operations of these intelligence activities?
No, sir. I never knew, he never told me that he even knew Oliver North, and he was very circumspect about his activities. I did not know what his relationship was until he testified in front of this body. I knew him and valued his insights on the Nicaragua situation because I knew that he had been involved in the State Department program. I did not know about his activities with regard to Colonel North.
This isn't the time for the members of the committee to engage in debates among themselves, but since others have expressed themselves, I will too. I don't find any fault with your opinion. It may or not be well-reasoned. It may or may not have unanimous support, but I think they're a respectable body of law that says indeed you were correct. And I suppose that's why lawyers argue and why the American public recognizes that we get so little done because there's so many lawyers. Well, thank you very much, Mr. Chairman.
Thank you.
Mr. Boland.
Mr. Chairman, I've found Mr. Sciaroni's testimony to be very useful and I think very instructive. It has provided an enlightening description of the methods by which the legal issues surrounding the Boland Amendment were analyzed by the White House. Mr. Sciaroni's opinion, introduced by the testimony here today, the product of a 5-minute interview with Oliver North and an unknown amount of time spent in legal research, not sought by anyone, hindered rather than aided by the White House officials whom the author interviewed. Obviously, dismissed by the President's National Security Advisor to whom it was delivered. That opinion stood until today in the backwaters of this investigation. Some might dismiss it as cursory and not fear being labeled as less than charitable. Others, however, have seized upon it as dispositive of every Boland Amendment legal issue from coverage to constitutionality. Whether you agree with it or not, the Sciaroni opinion is apparently the only legal analysis done in the White House on the statutory restrictions on provisions of assistance to the Contras. Think about that and consider what it tells us about the value the White House placed on adhering to the laws which have so occupied our attention over the last 5 weeks. Thank you, Mr. Chairman.
Senator Sarbanes.
Thank you, Mr. Chairman. Mr. Sciaroni, how long have you been the counsel to the Intelligence Oversight Board?
3 years.
How old are you?
35.
All right. What's that position pay? What's the salary of the counsel to the Oversight Board?
I believe it's about $62,000.
Now, I'm interested in how you came to get this job. As I understand it, you finished law school in 1978 or 79. Which was it?
It was 78. It was the end of the first semester, law school.
I see. And then you took the California bar. When
Right.
was that?
Sometime thereafter, I don't recall.
I mean, shortly after finishing law school?
I believe I was a fellow at, I went immediately to become a fellow at the Hoover Institution. I think that's when I took the bar exam.
All right. And did you take the California bar again, or just that failed at that one time?
I think I took it twice and failed both times.
All right. And then after that,
I should
what
point out
happened?
I was working at the time.
Understand. And then after that, what happened? You then came to Washington?
To the American Enterprise Institute.
Uh-huh. And then you took the D.C. bar?
Right.
And when was that?
Again, it was in the early 80s. I don't recall.
And did you take the D.C. bar just once?
I think I took it twice as well.
You took the D.C. bar twice as well?
I think so.
And failed it both times?
Right. Again, I was working and while I was studying for the bar exam.
I see. And then you were working then at the Department of Commerce, is that correct?
Right. After
And-
the Arms Control Disarmament Agency.
And then an opportunity came up to go to become the counsel to the President's Intelligence Oversight Board, is that correct?
Well, I'd left the Commerce Department the previous fall, and I understood the position was opening up in the spring, and I applied for it.
Oh, I see. You were out of the government at that point.
Right.
And what were you doing?
I was doing writing and reviewing job offers.
I see. And then how did it come about that you knew about this and went to seek this job?
Well, as I testified earlier, I knew the predecessor, my predecessor, informally, and he suggested he was leaving, and I submitted my application.
I see. Now, was there a job description for counsel to the Intelligence Oversight Board?
I don't believe there's a job description. I haven't seen it, if there is one.
Are you required to be a member of the bar?
I believe you are, yes.
Uh-huh. Now, you were not a member of the bar, is that right? At that
That's
point?
true.
Uh-huh. And when were you hired to do this job?
I was hired, do you mean when did I start work?
Well, I was going to ask that next. When were you hired?
Sometime in the spring I was notified that I would get the job pending passing the bar.
And when did you take the bar?
July,
And when did you go to work?
after I took the bar,
How soon thereafter?
the next day.
And when did you find out that whether you were in fact a member of the bar?
That fall.
So in other words, you were told that you had to be a member of the bar to take the job, but you actually took it well ahead of knowing whether you had passed the bar.
It was a condition of employment.
I understand that, but your employment had started before the condition had been met, is that right? Was the condition merely that you take the bar or that you pass the bar?
The condition was that I become a member of the bar.
And you went to work ahead of that happening, is that correct?
Well, that was the understanding. I could have actually assumed the position before I took the bar, but I did, having had the previous experience of working and studying for the bar, I figured that I should take all the time necessary to study for the bar.
Now, if you would turn to Exhibit 18. That's a memorandum, I take it, you prepared on the legal basis for covert action, is that right?
That's right.
And it's covered by a memo from you to Ollie North, which reads, and I quote, "Ollie, could you take a look at this draft and give me your comments? At your leisure, of course. Thanks," and signed with your name. Now, was it your custom to submit your draft legal opinions of the people over whom you were supposedly exercising oversight for their review?
Well, first of all, I was not exercising oversight over Colonel North. He's a member of the NSC staff, and we don't have responsibility over the NSC staff. Second of all, I, depending upon the memo, might send draft copies to any number of individuals in the U.S. government to ask for their commentary. So it would depend on memo to memo whether I gave a particular memo to an individual who I thought might be able to contribute some criticism.
Was North a member of the bar?
No, sir.
Well, why were you submitting a memo on the legal basis for covert action to North for his comments?
Because I assumed he knew something about covert action.
You earlier indicated that you don't know why you were the only one who was being asked to give opinions, I think, when...
I was never asked, or the board was never asked to give an opinion, but I did question why ours was the only one ever drafted.
Did it ever occur to you that you were providing cover by your legal opinions?
No, sir.
Well, I see my time's up. Thank you, Mr. Chairman.
Mr. DeWine.
Thank you very much, Mr. Chairman. Mr. Sciaroni, thank you very much for your testimony and being patient with all of us today. I think that it's obvious to you, and I'm sure everyone else, that this committee has used the opportunity, I think appropriately so, the opportunity of your testimony to again debate the Boland Amendment, or at least talk about the legality of it. And I think, again, as we listen to each member express his opinion about the Boland Amendment, we get into a little policy, we get into a little statutory construction, and we also get into the constitutionality of it. What is brought home, at least in this member's mind, is how murky it is, and how unclear the Boland Amendment is, and the fact that we have many members who have very divergent points of view. I have taken a look at your memos. I'm sure the other members have. I think it is a well-reasoned memo. I can see where people might disagree with it, they might agree with it. But we're into a very, very vague and very, very murky area, and I think it is clear that this committee isn't going to resolve it today. That's not our job. And I think it's also clear that at an appropriate time, a court is going to have to decide the constitutionality of the Boland Amendment. It's going to have to decide the statutory construction of that Boland Amendment, and specifically whether or not the Boland Amendment applies at all to the NSC or anyone else. I think that if we can break the analysis of the Boland Amendment down into three parts, we're really into a three-part analysis. One is the statutory construction. Does it in fact apply to the NSC? It seems to me that an argument could be made that applying it to the NSC and the members of the NSC flies in the face of a 40-year history of Congress not restricting the NSC, not dealing with the NSC. And it seems to me that if you were going to fly in the face of that history, Congress should have specifically mentioned the NSC in the statute. Congress did not do that. Furthermore, Congress did not even say prohibit the U.S. government from doing something. Congress was much more specific. I suspect that the reason Congress didn't do either one of those was because it wouldn't have passed. This was a product of a legislative compromise that ultimately had to be signed by the President of the United States, and I suspect if one or two had been used, if they had prohibited the action by the U.S. government, or if they specifically had named the NSC, the President of the United States would not have signed it, and I think the authors knew that, and I think the folks who voted for it on the floor knew that, and it was obviously legislative compromise. It was obviously intended, frankly, to be a vague bill. I think the second analysis is in the area of the Constitution. What is this constitutional? Is it constitutional, and how far do you take it? Do you take it to the point? Are the people who are criticizing your legal opinion, do they take it clear to the point where they say that Congress has the right through the purse strings to control what the President of the United States does? And it seems to me that is the logical conclusion behind what they are saying, that if you can control the people who directly work for the President in the NSC, whose sole function is to give the President of the United States advice to coordinate the foreign policy, who are not confirmed by the Senate, who exist really at the will of the President to serve him, and that's been the 40-year history of it. If you can control them by the purse strings, it's obvious that they think that you can control the President of the United States. And I think that then brings home the absurdity of the argument, that this Congress could, through an appropriation bill, some way stop the President from picking up the phone and calling someone and saying it might be a good idea to help support the Contras. I'm not saying he did or didn't do that, but it seems to me that's the logical extension of that. The further logical extension would be that Congress could prohibit the President from talking to a foreign leader about a certain specified area. And I think when we take that out, and I could give 10 more examples, but my time is almost up, but when we take it to its logical conclusion, we see how absurd that would be. But that debate is for another day, and I appreciate the fact that you've been here, and my time is up. Thank you, Mr. Chairman.
Senator Hatch.
Thank you, Mr. Chairman. Mr. Sciaroni, there's an old maxim in the law that says that hard cases make bad law. Now, with respect to the Boland Amendment, I think that the reverse may be true here. Bad laws make hard cases, including the ones that we're investigating here. Now, I say bad not because I disagreed with those laws, but because I feel that those laws were very unclear. And as a matter of fact, they may very well have been unconstitutional as well. Now, I take it, Mr. Sciaroni, that the basis for your legal analysis consisted primarily of the language of the Boland Amendment itself and the surrounding legislative history. Is that correct?
That's correct.
That's correct. Now, we've heard your explanation of your legal opinion, so I won't go through it again, but as I review your analysis, your opinion makes sense, regardless of some of the criticisms that may have arisen. And I might add that if we in Congress had wanted to include the National Security Council, we should have said so. And we would have said so. Now, in doing your legal analysis, I take it, you got acquainted with the history of Congress's decisions regarding the Contras, including all of the Boland amendments. Is that correct?
Somewhat, yes.
Okay. Now, you became aware that in 1982, we gave aid, then in 1983, we cut off aid. Is that right?
That's right.
That was the first Boland Amendment. And that was itself an interpretation battleground because the amendment prohibited funds for the purpose of overthrowing the Sandinistas. And the CIA thought that it could still provide support for the Contras because it saw its role as not to overthrow the Sandinistas, but to stop them from exporting their revolution. Is that correct?
That's correct.
And so there was that conflict right there that naturally arose, right?
Right.
Okay. And then in 1984, we gave them aid again. Congress turns right around and gives them aid, some $24 million. But then for fiscal year 1985, we passed the Boland Amendment that you were studying at the time. Is that right?
Right.
Okay. And to further confuse the issue, later that same year in 1985, we actually appropriated another $27 million for the Contras. Is that right?
That's right.
Okay. And then in 1986, we cut off the funds again. This is Congress doing all these things. And we passed yet another version of Boland, which this time allows for information sharing between the CIA and the Contras. Is that correct?
That's correct.
Okay, and that one got us into another interpretation battle because nobody could agree on what, quote, information sharing, unquote, meant.
Right.
Okay. Even the House and Senate Intelligence Committee chairman disagreed on what it meant. Is that correct?
That is correct.
Okay. And that was in a response to the CIA director himself at that time. Is that right?
That's my understanding.
Okay. Now, during this same period, say fiscal year 1982 to 1987, when we in Congress were passing these series of Boland amendments, when we were for aid one year and against it the next, what was the president doing? What was his position regarding Nicaragua?
Excuse me?
What was the president doing? We were going back and forth and up and down and all around. What was the president's position? Did it ever change?
He had a consistent policy.
So he stayed consistent. His
Right.
policy was, we can't allow this to exist. We've got to do everything we can to stop it, etc.
That's right.
Now, your legal analysis that you made did not look at the constitutional question. Is that correct?
No, it did not.
Okay. Now, Article 2 of the Constitution gives the president the authority to conduct foreign affairs. Am I correct there?
That is correct.
And Article 1 gives Congress the authority over appropriations. Is that right?
Right.
Congress controls the purse strings. Is that correct?
That is correct.
Okay. Now, does the president have any constitutional authority over Congress's appropriation power?
Does he have any constitutional?
Authority to deal with Congress's appropriation power?
Well, he can veto it.
He can veto any particular bill. And,
Surely.
of course, if the president vetoes the bill, the Congress can then, by having a two-thirds vote, override the veto. Is that correct?
Right.
Now, in a similar sense, Congress also has a form of veto power over the president's foreign relations activities or foreign policy activities, in that Congress may refuse to appropriate funds. Is that correct?
That's right.
So we have a back-and-forth constitutional leverage here that exists between the president and Congress. But Congress may not completely take away the president's resources to carry out his constitutional authority over foreign affairs any more than the president may completely take away Congress's authority to appropriate funds or withhold the appropriation of funds. Is that correct?
I would agree with you.
So that's the constitutional standoff. In other words, Mr. Sciaroni, aside from what appears to me to be the obvious benefits of allowing foreign policy to be conducted by the executive or the president alone without any undue interference by Congress, there also comes a point where Congress may not, under the guise of its appropriations authority, take away the President's constitutional authority to conduct foreign policy. Is that correct?
Correct.
And here we have a mishmash of rules and cases where that may have been the case. Mr. Chairman, I'm just about through. One more question. And to the extent that the Boland amendments are now, after the fact, being interpreted as applying to the President and to the NSC, the National Security Council, to prohibit the President from doing anything, including talking to private citizens or foreign government officials about support for the Contras, to that extent, the Boland amendments would be in serious constitutional trouble. Wouldn't you agree?
I would agree that's overreaching.
Well, I would too, and finally, I would love to just discuss this further with you. But to make a long story short, I think we've covered a lot of areas here that are very important. And that is, Congress has been sending inconsistent messages while the President remains consistent. Congress has, in this process, never applied these to the NSC or the President. Now, after the fact, is trying to do so. And Congress has a right to withhold appropriations or grant appropriations in a certain way, but not the right to micromanage foreign policy, and that's frankly been the problem here. I want to thank you for being with us.
Thank you.
Senator Heflin.
Mr. Sciaroni, reviewing sort of the status of where we are, I gather that the proponents of the Boland Amendment, who say that it's included the National Security Council, that their language, and supposedly supported by the debate on the floor, was that the words any other agency or entity involved in intelligence activity was so broad and so inclusive to have included any other agency or entity of the government that was connected with intelligence activities. Now, as I understand from your legal opinion, you do not debate the broadness of the term involved, but your legal opinion comes down to the fact that you say that the language involved in intelligence activities is a term of art that restricts that language and those entities and agencies to those that are listed in statutory language or the executive order where they are included under the term intelligence community. In other words, it comes down not that the language involved is not broad enough, but to a term of art interpretation that you have given to it that therefore limits the sweep and what comes within the language. Now, I don't see in your opinion, nor have you explained wherein your authority is that this is a term of art. Now, as I understand it, a term of art is language that comes to have special meaning in a particular field or profession from usage. Can you point to us wherein in the statutes or in executive order there is such usage and language that therefore limits the words involved in?
Well, I would say this by way of explanation, that the legislation to which the Boland Amendment was attached did define, from my standpoint, the universe of organizations that were involved in intelligence activities. And I think that the executive order, which has been cited previously, also does the same thing. For example, it states that intelligence activities means all activities that agencies within the intelligence community are authorized to conduct pursuant to this order.
Well, therefore, then I would interpret it, if you were writing the Boland Amendment, that you would have to say that you'd have to have language in substance that says that all agencies or entities within the intelligence community and all other agencies and entities involved in intelligence activities in order to be an inclusive and to be broad enough to get the National Security Council involved in it.
That's one way that that could be done. May become involved would be, I think, language. And at that point, I think the constitutional issue would then be joined.
All right, so is the Intelligence Oversight Board an agency or entity involved in intelligence activities?
It's a, no, I would say we're not involved in intelligence activities. We're not an operational unit.
Well, now let me ask you this, if you had, and give this as a hypothetical, in the event that Congress were to pass a law that says that for each employee of any agency or entity involved in intelligence activity, that they shall be entitled to receive an extra $5,000 per year for their salaries, couldn't you make a pretty good case under that basis that the Intelligence Oversight Board and the National Security Council was an agency or entity involved in intelligence activities?
I'd be sorely tempted.
That's all.
Is that all? You through? There being no further questions, Mr. Sciaroni, you are excused. We thank you very much for your testimony.
Thank you very much.
The committees will have a 10-minute recess before the next witness.